everyone. Welcome to the second session of the Title Standards Seminar. As I'm sure most of you are aware, we hold this in two sections. So we had a morning session a couple weeks ago. If you did not attend that session or missed it for whatever reason, there will be a recording available. Email myself or Elaine and we can get you a link to that. For today's session, a few housekeeping items. One, materials are available through the QR code. You should have received a little information sheet with the speakers, and there's a QR code at the bottom. If you scan that in, the presentation materials will be available there. Two, there will be a replay of today's session as well. So if you need that or would like to refer back to it, please feel free to reach out. We can get you a link to that. It will be a couple weeks before that's available. We can get you a link for that when it becomes available. And third, for those of us who are joining us in person today, after today's session, we will have a reception afterwards out in the lobby. So please join us for that. And now, without further ado, our first speaker is Kenny Stroud with CADIC. He is speaking on ethical use of artificial intelligence in title. And it's a primer for settlement service professionals, which I think applies to all of us. And I will let Kenny take it from here. Thank you.
Thank you, Amy. So, real quickly, with a show of hands, how many people in the room use AI personally or have used AI personally? Okay. Same people, how many people have used AI professionally? Number. AI is everywhere, right? You can't Google something or go on Microsoft Bing and search something without using an AI. You may not know you're using it, but you're using it. And so one of the things that we want to talk about here today is if AI can make our lives simpler, easier, more productive, and if we're going to adopt that in our profession, is how can we do so ethically and in a compliant manner? That's where the bulk of our conversation is. Now, what this conversation, this topic is not about is what is AI, although we will talk briefly about that. What can I use it to do, though we do have some examples. It's mostly focused on if we're going to use AI, how do we do so within the bounds of the rules of professional conduct and just general ethical considerations. And again, I told you all. All right. We'll just go and use this. Okay. So that was our introduction. So AI is everywhere. Question is, are we using it the right way? Qualia, which is a settlement services software provider, did a recent poll of 631 participants. And from that poll, the information that they gathered, they put together a report called State of AI in Title and Ethics. And there's a link to the report here, but if you Google it, you can find it as well. And I reviewed that report and I found something very interesting. Out of 631 survey participants, 90% reported using some form of AI, which is consistent with the number of hands that were raised in this room. 58% of those participants reported being optimistic or very optimistic about AI's benefits for their practice. And then 86% believe that AI will change their roles in 3 to 5 years. Come back to that. So there's some takeaways that we can glean from this information. One, AI is here to stay. There may be some folks who are very reluctant to adopt its use, and that's fine. I think we need to take a cautious approach to do that. But it's permeating really everything that we do, and it has the ability to greatly enhance what we do in our practice. The other thing is cautious optimism, with the largest risk category being fraud and data security. That is where the two main concerns are coming from. So participants are viewing AI as a good thing, but they're concerned about fraud and data security, and also, is AI going to take our job? We'll talk more about that. And then finally, a shift from routine task execution to oversight, analysis, and client engagement. That's important. Come back to that. So what is AI? Well, unless you've been living under a rock for a really long time, AI is basically a term of art. It's artificial intelligence, but it describes the use of computer-generated large language models, which are capable of taking in vast amounts of information, learning, and generating outputs. That is generative AI. And so examples of that would be ChatGPT, Grok. Those are just two of the main ones that are used. But it also includes specific or industry-specific or area-specific uses of artificial intelligence. So what is AI currently being used for, or what are the emerging use cases? What is it being tested on? Well, file processing. So opening a file, doing order intake in the file set. I know some softwares have the ability to scan and review contracts, glean the important information in the contract coming out of that, and put it into the software automatically. Obviously, that needs to be double checked to make sure it's done so accurately, but that saves time, right, in entering that information. Generating client communications, whether it's based on a template that you have created before, or it's completely generated by AI and the attorney is reviewing it before it goes out. Letters to buyers and sellers, letters to lenders, or representative counsel for those parties. Title searching. This is where things are getting really interesting, honestly. Is the ability to go out and search records that are available online, pull copies of deeds or images of deeds, and analyze them. And what is ultimately, in my opinion, and I think a lot of people's opinion, is a tool to aid the attorney in the review of title. It definitely should not replace a full review by the attorney and or the exercise of the attorney's professional judgment about what's but there's a lot of efficiencies there, right? What took days can now take hours. What costs hundreds of dollars can cost a fraction of that, right? So you want to be able to take advantage of these efficiencies if you can do so in that compliant manner. Underwriting Copilot. We have seen AI tools be able to analyze a document. For example, deed to secure debt. You can ask AI, go through this document, scan all the text, and tell me what the maturity date is, and if there's language in there that purports to create a perpetual or indefinite security interest. Does it always work? Most of the time. So I would encourage you, if you're going to use something like that, make sure that you're double checking it. But it does save you, instead of reviewing like a 30-page security deed for this 2 bits of information, you can quickly glean that. And a lot of the AI tools will actually mark that where it's at in the document and point it out and take you to it so that you can. Doing research, locating statutes. One of my colleagues in Connecticut, Connecticut has a very robust title standards. It's like 600 and something pages. It's a lot. And so he uses it because he's gone through it pretty much in its entirety throughout his career at one point or another. But if you're looking for a specific rule or a specific case or something like that in the title standards, you can use AI to parse through a 600-page document and take you to exactly what you're looking for. That's time saving, right? So that you can do that. Locating statutes in jurisdictions that you're not familiar with and may not have access to through other traditional tools. Identifying relevant underwriting concepts. So, for example, talking about the security need and whether or not a security need has reverted under the law, under the reversion statute. That's something. Looking at a judgment lien and determining if it is beyond the statutory period and it hasn't been renewed, has that judgment expired? AI is capable of doing this for you. Obviously, you should double check it and make sure it's right. We'll talk more about that in just a moment. But I wanted to point out, those are just a few of the emerging use cases. What we're starting to see now is a shift from generative AI, which is where you give AI some whatever information or documents you want it to analyze and ask it a question to generate a response, to more like agentic AI, which is where AI is acting as an agent of you and for you. There are certain AI agents out there now who can request HOA estoppel letters, obtain municipal lien searches in states where those are required, obtain mortgage payments, fill out forms that are necessary for this information gathering. And they can make voice calls on your behalf. I've listened to one, they sound pretty real. Pretty shocking, actually. But they can do things for you and on your behalf that you would otherwise have to spend time doing. So it's not just, hey, review this document, analyze it, give me the answer. It's, I'm going to act as your agent. Very interesting. So going back to what we said at the very beginning. If AI is here to stay, and if it can be used to increase productivity, efficiency, and enhance the practice, how do we use it ethically? Right? That is our number one concern as attorneys. We're subject to the rules of professional conduct. The community as a whole holds us to a higher standard as attorneys. And so we want to make sure that we are always mindful of our ethical duties. So let's talk about some guiding principles. There's really two that I want to, overarching theme that we need to talk about. Before we do that, I want to show you an example of something that I think is not the message we should be communicating. So this was a picture that I took of myself in New York City. I was there for the All-to-One conference in October. And I was staying not at the hotel where the conference was, down the street. And I got to my room. First thing I did was open up the blinds and take a look out this place. This huge billboard that says, "Stop hiring humans. Era of AI employees is here," right? So I just had to laugh, and I took a picture of it, and I sent it to some of my colleagues. And I said, AI is coming after our jobs. Right? There may be some truth to that in the sense that if your job is just doing task-oriented things, maybe, okay? But as attorneys, this is not the message. Attorneys in title practice, real estate litigators, whatever you do, title examinations, you should not, this is not the message that we should be sending. We need to stop hiring humans. We need to invest in humans to continue to learn what our profession requires. We should invest in humans to understand, to carry on for the next generation, all of the knowledge and expertise that we have worked to gain. Does it make sense to use AI to assist us in that process? Yes, I think it does. But overall, the message is that we should not, stop. We should not be telling people to stop hiring humans. Talk about in just a moment what we think the message should be. So I believe that people, specifically lawyers, are essential. What I mean by that is when it comes to the use of AI, artificial intelligence should augment, not replace, human professional judgment. Now, what does that mean? Well, that means you can use AI to help you analyze a document or glean an answer from the text or summarize the text or write an email, whatever the case may be. Ultimately, you, as the attorney, are responsible for the product that goes out, right? And so you can use AI to help you in that process, but you cannot substitute AI in for your human professional judgment. So if AI is telling you this document says X, and you read the document and it's like, no, it clearly doesn't come from X, name Y. That is the exercise of your human professional judgment. You are acting as a checker against the use of AI. You're correcting it. So that's the overall kind of arching theme. But under that is, and these next two quotes actually come from the generative AI toolkit that the State Bar of Georgia put together. They assembled a committee on AI and technology, a subcommittee, and spent a lot of time studying this and issued that generative AI toolkit. I'd strongly suggest you go visit that, find that resource and bookmark it. It's really great resource. So this is a quote from that. Technology may increase efficiency and productivity, but it cannot replace trust, expertise, and judgment or serve as a substitute for a lawyer's ethical obligation. I think that's a fantastic way of summarizing it. It's a very useful tool. It's just a tool. It cannot substitute for the attorney's ethical obligations. Another quote, ultimately, AI is a tool. It cannot apply legal reasoning, understand justice, or assume ethical responsibility. That remains the role of the lawyer, right? Now, the generative AI toolkit that this is pulled from, that's speaking to the bar as a whole, not just the real property law section. But I think it applies just as equally to us, right? We need to understand that AI cannot apply legal reasoning, nor can it assume my ethical responsibilities as the attorney handling the transaction. The other kind of overarching theme, one is AI should be used to augment, not replace human professional judgment. The other overarching theme is to trust AI. We need to know where it is getting its information from and generating its results, right? This is referred to as the black box problem. Nobody knows what a black box is, like an airplane, right? So in the unfortunate event of like an airplane crash, the first thing they want to try to locate is the black box, because the black box records everything that transpired, whether it's digital readouts of the radars or anything like that, the speed at which the plane was traveling, the altitude. It helps the investigators point to what was the cause of the crash, right? Similarly, if we're using AI and we're saying, okay, AI, what is the answer to this question? You ask it a question and it gives you a response, but it doesn't tell you where it got that information, what that response is based on. You've got a black box problem. Another way to put it is the underlying basis for that response or that answer is hidden away in a black box that you can't find, right? That's a problem when you're using AI. You always want to know, one, what the response is from AI. Two, where did it get that response? What information or documents did it rely on? And how did it approach its reasoning, right? So we'll talk more about like, how do we get to the root of that? But ultimately, there are certain forms of AI out there where you ask it a question, it tells you an answer, but it doesn't give you the backup information. It doesn't show you how it arrived at its conclusion. I would strongly encourage you stay away from those, right? Don't use that. Any AI you're using should be able to explain, here's your answer, here's links to the documents or information where I gained my information from and gave you this response. That way you, as the attorney, can go back, verify it, and double check it. So talking about using AI to augment your professional responsibilities, but not replace your human professional judgment. One of the things that is absolutely necessary is a human in the loop design, right? You've got to have a human in the loop in order to determine if AI is producing the right outputs. So one of the strategies that we talk about this internally in my company, and I know other companies have as well, is let's figure out, the goal is to deploy the right balance of people and technology in the process, right? Yeah. Technology, and specifically AI, can greatly enhance your efficiency and your productivity and make the practice of law that much better. But the goal is you've got to have the human. So how do we do that? Well, you got to ask yourself a couple of questions. One of those is, what work do humans do best? And then what work do machines do best? Okay. Well, if you think about what work do humans do best, human professional judgment, analysis, legal reasoning, understanding communications and the tone in which those communications are sent. A lot of things that the human brain is capable of doing that AI is not necessarily the best at, right? And so you need to think about, this is the kind of work that we need to be dedicating solely for humans in the world. And then what work do machines do best? We'll go over this in just a little bit more in a second, but think like task-oriented type stuff. Stare and compare, document review and reading, gleaning some information, things like that. But the point is, if humans must make all final decisions, then people are necessary in AI assisted workflows. And I like that because, again, we're not sending the message that you should stop hiring humans. Our message is humans are necessary because they must remain employed. They're necessary in AI assisted work. Another thing that we have to be concerned about is sort of overall regulatory framework in what we operate. So the room who are licensed and duly appointed title insurance agents or insurance companies. The insurance companies are regulated, heavily regulated, but the National Association of Insurance Commissioners and bulletin on the use of artificial intelligence systems in or by insurers. And this is a quote from them. It says, these standards require at a minimum that decisions made by insurers are not inaccurate, arbitrary, capricious, or unfairly discriminatory. Compliance with these standards is required regardless of the tools and methods insurers use to make decisions, right? So what we have to operate within this larger framework, if you're a licensed title insurance agent, to comply with it. And what it basically says is you can use AI to assist you in reaching a decision or not reaching a decision, analyzing your willingness to insure. Ultimately, the decision to insure or not to insure, the decision to require X, Y, and Z in order to insure must be made by the human professional judgment. Right? So that's just reinforcing the idea, the concept, the overall theme that we're talking about is the human is necessary in the world. What will our jobs be, right? Once AI becomes part of everyday life and everyday life, what will our jobs be? Well, think about this. Repetitive, sort of mechanical tasks will be handed over to AI. What kind of tasks are those? Research and info gathering, stare and compare. AI is great at comparing legal descriptions from deeds over time and pointing out inconsistencies. It's really, really good at that. Data entry or rekeying, information that's in one source, getting it into a different format or a different source. Transcription. I'm sure a lot of you, when you're on company meetings or Teams calls, you record those and use the transcription tool. That's AI based, right? So there's a lot of things that AI is really good at and is really a good use. What I think we're going to see is that people, humans, will be repurposed into higher value activities. Right? What do I mean by those? Well, quality control of AI, right? Looking at the documents, looking at the outputs from AI that you're using, making sure that it's right, making sure that it's consistent, making sure that there's no bias in how it's reviewing those documents. We'll talk about hallucinations in just a second, but I had a situation where a person called me and said, hey, I asked AI the question. I think it was something to the effect of, if someone sues on a promissory note or personal guarantee, gets a judgment on the promissory note, personal guarantee, and then they foreclose on a piece of property, do they have to confirm the foreclosure sale before they go back and try to collect on the judgment? And I had researched this years ago. In the back of my head, I was thinking, no, I don't think so. I think there's a case out there that you don't have to do that. Well, AI, he had asked AI, AI said, I won't mention which one, but it said, yes, you absolutely do have to confirm. And so right there is an example of AI giving the exact opposite answer as to what the law says. So you have to be careful in using, broad-based AI tools like ChatGPT and Grok. But quality control, training AI, understanding how to train the AI models and the AI technology that you're using through prompt engineering, being very specific in your inputs and requirements, evaluating and reviewing the data that's going into it to make sure that the data is verifiable and accurate, things like that. Interacting with other people. I mean, yes, I know we talked about agentic AI can be used to make phone calls on your behalf, to gather HOA estoppel letters and things like that. But when it comes down to it, what we do in the real estate profession, and specifically real estate law, is primarily relationship based, right? It's all based on relationships, whether that be lenders, buyers, sellers, realtors, everybody in there, there's a relationship aspect to that business. That's where AI falls way short, right? You as the attorney are responsible for cultivating those relationships and developing those relationships. And ultimately, this is the big one, making all final decisions, right? Because ultimately, if you make a decision, it's not an excuse to say, well, AI told me to do it this way, or this is what AI told me, so that's what I just repeated without, verifying it or checking it. Ultimately, it's the lawyer's responsibility to make sure that what they're putting their name and their signature on is accurate, they understand it, they believe that what they're saying is correct and true, right? So that we want to highlight that because I think that's a good way of segmenting what can we use AI to assist us with and what do we need the human to take ownership of, right? In terms of making sure that we have AI assisted workflows with the human. So how do we verify AI generated content? Well, everybody's always heard the old saying, garbage in, garbage out, right? It's no different with AI. If you put it this way, if you go to, let's say, Google, and you ask it a general question, a legal question, it's going to give you an answer. That answer may or may not be correct. I have seen instances where you will ask it a question, and it will come back and tell you the correct answer for New Mexico, but not Georgia, right? But even if you put Georgia in there and say, what does the law say on this in Georgia? It will come back and give you information on Texas or Nebraska. It's not capable of, because it's taking so much information that's available on the internet and using that, trying to synthesize it down to answer the question. It's almost like information overload. So that's where you have to be very specific in your question. But if garbage is going in, and let's face it, not everything on the internet is true, right? So if garbage is going in, garbage is going to come out. And that's what you need to be careful of. So flesh and blood legal professionals are necessary to ensure the quality of the data that's going into the AI model and the outputs that are coming out of the data, whatever its use. So this is what we get into an interesting phenomenon of AI. What is an AI hallucination? Well, basically, it's where AI goes off the rail and creates something that's not true, fictitious, or in some manner just flat out incorrect. Right? Here's a good example. This is one of the earlier known examples of AI sort of being called out for its hallucinations. So in this case, it was Mata versus Avianca, and it involved an attorney who used AI to prepare legal briefs and submitted those legal briefs to the court without checking whether every citation was correct, accurate, and actually existed. And it turns out they were hallucinated cases. Those cases did not exist, even though they had a cite to a reported, a reporter. they didn't exist. And so this came to light, and this is a quote from the judge. He says, the judge added that the technology was evolving and was prone to provide hallucinated cases, laws, or facts. That's scary. This is why close and careful attorney supervision, fact checking, and citation checking are absolute necessities, right? So it's interesting the posture here, right? The judge doesn't seem to be anti-technology or anti-use of AI. They seem to be saying it's fine if you want to use AI, but you, as the attorney, remain solely responsible for the truthness, the veracity, the accuracy of what you're filing. Right? So that's very telling to me that judges are saying, we know AI is going to continue to be used in the practice of law in many different facets. So it's not that we're criticizing its use or trying to dissuade you from using AI. We're trying to remind you of your professional and ethical obligations if you're going to use it, which is what sort of informs our basis for this presentation. So prompt engineering. This is where you can ensure, help ensure that the information that's going into the AI model and the outputs that are coming out of the AI model are as accurate as possible, right? So what is prompt engineering? Well, it's quickly becoming a degree, believe it or not. There are colleges and universities out there who are offering degrees in use of artificial intelligence and technology and prompt engineering, right? And so actually going to school to learn how to properly communicate with an AI model through prompt engineering to generate good, high quality outputs is becoming an educational course. And so what it involves basically is the use of precise questions or language and instructions in a chat prompt. What this does is the more precise that you are, and the more precise you are in the information that you give to the AI model, whether it be documents or just prompting and information that you're giving, it's going to control and affect the AI's behavior and the outputs that it generates. This is all done in an effort to reduce those AI hallucinations, right? So an example of this, Photor is an AI-based photo generator. And we prompted this, my colleague and I prompted this. We just said, okay, our only prompt is make a house, right? And this is what it gave us. This sort of dreary, black and white, looks to be like a single story picture of this house. Not very great. Is it a house? Yeah, I think so. I mean, I don't know that anybody lives there, but looks like. But then we got more specific. Right? We used prompt engineering to specify for AI what we wanted. And that's the picture that we got. And what we said is create a modern 2-story suburban home with landscape yard, white picket fence, and sunset lighting. Okay. Well, AI took our specific prompts that we were giving to it, as opposed to a generic prompt. And it created something that is very close to what, if not identical to what we wanted it to create, right? That's how AI works. So if you're looking specifically for AI to do a very narrow subset of something, that's what you have to instruct the AI to do. And the more that you do that, the better the results. So that's prompt engineering is a way of safeguarding against AI hallucinations, and depending on what you're using it. So overseeing AI-driven processes, responsible use of AI includes the following: verifying accuracy of inputs and outputs, reviewing it to prevent bias. I saw this on LinkedIn the other day. It was very interesting to me. And no disrespect, not dissing on Mississippi. If you're from Mississippi, we love Mississippi. But I saw on LinkedIn the other day, somebody was talking about the bias of AI. And I think the question they asked it is, which is the laziest state of all the states in the United States. And I think it was ChatGPT said Mississippi. And it was like, well, what information did you base that on? You know, it's like, that's a very subjective type question. And they were doing that, they were saying that, they were making the post to kind of demonstrate, hey, there is an inherent bias that could be in the use of AI. And you need to be mindful of that, and you need to guard against that bias. So you need to, make sure that the AI system you're using isn't biased in a certain direction or towards a certain outcome. Ensuring data security, this is huge. We have calls with our internal IT security team all the time, on data security and privacy, NPI, all this stuff, and no different with the use of AI, right? You need to make sure that if you're going to use it, you got to make sure that that information is encrypted, protected, it's housed in a manner that can't be accessed unlawfully. You got to protect your intellectual property, whether it's your firms, yours, your companies, whatever the case may be. You can't just be putting it out there and affecting your IP. And then, of course, complying with governance and regulations that are handed down. So quality control in a nutshell is human validation is essential to ensure accuracy and trust. Accuracy of the outputs and trust in the AI outputs that are given. Title professionals and agents play a critical role in overseeing that process. You are the last line of defense, right? If you're going to use AI, you have to own it. You have to understand how it works. You have to understand what's going into it and what's coming out of it, and you have to verify its accuracy. There's nobody else but us to do that, right? And that's where that human professional judgment comes into play. And then, of course, final decisions, whether it's where should we go with this case, advising the client on the procedure going forward, or what your advice is going forward, making decisions to ensure about what's necessary to correct and give marketable title. All of those kinds of things have to be done by humans, lawyers specifically, exercising independent professional judgment, right? And so I put here a reference to the rules of professional conduct because I think that informs us as attorneys what we have to keep in mind when we're looking to establish good, robust quality control. So I would break it down this way. I think there's 5 sort of core duties of the lawyers that could be implicated in the use of AI. And those duties would be the duty of competence, which is rule 1.1, duty of confidentiality, which is rule 1.6, duty of diligence, which is rules 1.7, 1.8, 1.9, duty of transparency, both in fees and in your obligations to the court, that's rule 1.5 and 3.3. And then supervision, this is where it gets really interesting, rules 5.1 and 5.3. So I just want to go through each one of those rules. That's where we'll spend the rest of our time. So, Georgia Rule of Professional Conduct 1.1. I'm paraphrasing here because these rules are a lot longer in written than what I could fit on the slide. So basically I'm paraphrasing. It says rule 1.1 says, lawyers shall provide competent representation of the client. Right? What does this mean? Well, if you read the comments to our rule, it basically says it requires that the attorney have the knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Right? What it goes on to say is if an attorney does not have experience in representing a client in that particular type of matter, that doesn't necessarily mean that they're not competent. If they have the time, willingness, and ability to educate themselves, to research, and to become competent as part of the representation, then it's not a violation of the rule to take that representation on. I think clearly you'd want to inform the client that you don't have a lot of experience in that area, but you're willing to, put in the time and effort and resources necessary to educate yourself and become very familiar with it. But I want to make sure, here's the big thing here. Using AI to fill in gaps of competency, that may be a problem, right? So if you're an attorney that doesn't have experience, I don't know, let's say drafting a joint reciprocal easement agreement between out parcels in a commercial development, right? You may not have any experience with that, but your client may want you to do it. Do you take that representation on because your client's wanting you to do that? Or do you tell the client, no, I don't, I've never done that, or I don't have any experience, we need to bring somebody else in? Or can you spend the time to acquire the knowledge, skills, the training, and the expertise necessary to make you competent in that area, right? AI can help you with that research and learning piece. If the information you're getting is accurate, you'd want to check that. So it can help you become competent. But if you go into AI and you say, draft a joint reciprocal easement agreement between out parcels in a commercial development, and it spits out a document, and you pass that off as your own, that's likely a violation, right? But if you want to spend the time researching what are the necessary elements, who needs to sign, how do I, how specific do I need to be with the legal description? Those sorts of things. Understand how you're going to go about that. I think that's an okay use of AI to educate yourself to get to the level of competency where you can take that. But simply using it to substitute or to fill in the gap of your incompetency, I think is probably a violation. So I use this example here, using AI to analyze legal issues on title without an independent ability to do so. So let's say you say, okay, AI, run title on this piece of property and tell me if there are any issues, right? Analyze any legal issues on title. That's fine if you know how to do it independently. If you know how to run title and research it and understand and analyze those legal issues on title, because you can check what AI is giving. If you don't have the independent ability to do that outside of the use of AI, I think you've got a violation of the rule of competency issue, right? Because you don't know what AI is generating for you is accurate or not. And that's the main point here in terms of evaluating competency. So the rule, if AI is to be used, lawyers must understand how AI works, how to use it properly, and know its limitations, right? You can't even begin to use AI unless you know those things, unless you know how it works, where it's getting its information. Remember the black box problem? And your ability to evaluate, i.e. verify its accuracy at the end. This all brings back and ties in that the human/lawyer oversight of AI is imperative, right? And I think that's just a nice little bow on, hey, don't use AI to substitute for your professional judgment or fill in gaps where you're not competent to take on representation. Next duty is duty of confidentiality. And this is Georgia Rule of Professional Conduct 1.6. A lawyer shall maintain in confidence all information gained in the professional relationship with the client. Again, more to the rule and paraphrasing there. So what we need to be concerned about here as how this intersects with AI is a lawyer may unwittingly or unknowingly disclose confidential information by inputting it into an AI large language model. Okay. Generative AI tools use information to learn and inform outputs to third parties, right? So let's say your client has given you a set of confidential documents, maybe documents relating to due diligence on a piece of commercial property. And you want to use AI to review those documents and do your own sort of due diligence. Understand, what's said about that property, environmental issues on the property, entitlements, zoning, whatever the case may be. And so you take all these documents and you just upload them to ChatGPT and you say, hey, ChatGPT, give me a summary of every document in here, 1 paragraph summary of every document. Right? Guess what? You just unknowingly, unwittingly exposed your client's confidential information to the whole internet. Because ChatGPT, with one exception, we'll talk about enterprise models, but ChatGPT It uses information you give it to answer questions that third parties ask it. Right? That's how AI, that's how large language models work. You give it information, it learns, it uses it to answer your question, but also everybody else's. Right? So if you upload a document, let's say it's a sensitive, confidential document, and then some third party, innocently enough, asks a question that somehow ties to that document, it could pull that document up as an example. Now, all of a sudden, they've gotten access to a confidential document, one that was shared with you by the client that's protected under Rule 1.6, right? So, again, keep in mind, this is very serious. You don't need to be sharing confidential information, documents or other information with public use AI platforms without completely de-identifying who the client is or redacting confidential or sensitive information. And at that point, what's the use of using AI at that point? You can just review the documents yourself, right? What most practitioners and what the generative AI toolkit recommends is consider using an enterprise level AI tool that limits the use of data internally or eliminate any identifiers to tie the data to the client. So an enterprise level AI tool is one which an enterprise or a company can purchase, pay a subscription for the use of that AI, but it's limited to that company or that enterprise's servers. It's limited to the information that is housed within that company confidentially and securely. It doesn't get access to outside third-party information, and it doesn't share with third parties outside of your organization the information, right? So that's big for our company. That's part of our AI policy. We're going to, within our company, use AI. We have AI models that are enterprise level that are secure to our company, right? And that's something that, but if you're a solo practitioner, you may not have ever thought of it, right? You're like, well, I don't have to pay for ChatGPT or Grok, so I can just use that. You want to be very, very careful. And at a minimum, you want to make sure that you're not uploading any confidential information to those sites. Another thing about confidentiality is you want to disclose the AI use to your client and get your client's consent to use the client data with AI. They may not know that you plan on doing this, and they may have an objection to it, right? So you're going to want to have that conversation with them if you plan to use AI to analyze a subset of documents. And then, of course, the lawyer should verify the data security of the AI platform, both inside their organization and if they're using one outside the organization, to ensure privacy and protection of the client. But you didn't think we were going to talk about data privacy today. So that's important, duty of confidentiality. The next is duty of diligence, right? So this is kind of a summary statement of these three rules. Taken together, these rules provide that a lawyer may not represent a client if the lawyer's interests or duties to another client or former client would materially and adversely affect the representation. This is interesting. This is an example of what's given in the State Bar's generative AI toolkit is using AI to screen clients or accept client orders may not catch potential conflicts, right? So think about the situation where you're using an online AI-based assistant where, let's say, sellers, buyers, and realtors can upload contracts to your website, right? And into your pipeline. So, hey, go on, schedule your closing, do everything online, right? Great in theory, sounds awesome. But what if you have a conflict, one of the parties? What if you don't just do closings? Let's say you do litigation as well. And you have just sued or are planning to sue on behalf of another client, one of the parties involved in the transaction. You need to be able to screen that properly before you accept that order, before potentially confidential information is given to you that conflicts you out of both representations. You want to be careful about the use of AI in that regard because it could lead to an accidental acceptance of information from a putative or a potential client that could lead to an actual or probable conflict. Using AI to chat with potential clients or answer inquiries could result in a client disclosing information that could raise a conflict or be deemed giving legal advice in the absence of an attorney-client relationship. Right? So, the interactive chat bots that you see on a lot of websites, it's fine if you want to use AI to gather some basic information, but you don't want the client sharing confidential information through those, right? Because one, you haven't, no attorney-client relationship, and you need to evaluate whether you can take that representation on or if you have a conflict. The other thing is if it's generating responses on your behalf, you're responsible for those responses, whatever they may be. That's where you need to be as a lawyer. I personally would not want somebody speaking on my behalf, without me being able to see what the response is, review it, verify it, and then release it to be returned. So duty of diligence is another area where in potentially screening clients and avoiding conflicts where AI could be used. Duty of transparency. So this is rules 1.4, 1.5, and 3.3. So rule 1.4 requires that a lawyer reasonably consult with the client about the means to be used to accomplish the client's end. That's pretty broad, but put it this way, if AI-assisted workflows are to be used in the representation, you should disclose that to the client and get their consent. Okay? So if you are in a residential closing practice or a commercial closing practice, and they come to you and they have a contract purchase and they say, I want you as my attorney, let's say it's commercial, I want you to perform the due diligence. I need you to research zoning, entitlements, environmental, all this. You say, that's fine, but I want to use AI to assist me so that it doesn't take me 20 hours to do it. It takes me 5. Well, that's fine. The client may consent to that. They may say, well, that's great because you're only going to bill me for 5 hours. We'll get to that one in just a second. But you're only going to bill me for 5 hours, not 20 hours. So I'm okay with that. But you want to disclose that to the client because the means that you're using to achieve the client's objectives involve use. You're going to want to have that conversation, disclose it, and then get their consent. On the other hand, client may say, nope, don't go anywhere near AI with my information. I want you to do this personally, and I only want you as the person who's doing it too. So just keep that in mind. Rule 1.5 provides that a lawyer's fees for representation may not be unreasonable, which depends on a number of factors, right? So if AI is to be used in the representation, the lawyer must consider how such use impacts fees charged. If use of AI for due diligence saves time, is a flat fee based on human time reason, right? So think about that. You may say, I'm going to charge $5,000 to handle this transaction. And that's based on your estimate that it's going to take you 20 hours of time to research title, draft the docs, prepare the closing, handle the closing, do post-closing, follow up, all that stuff. If you quote that flat fee and then you turn around and use AI to get it done in 2 hours, is your fee of $5,000 really reasonable, right? I think it would be if you disclosed it to the client and said, hey, I'm going to use AI to make myself and my practice more efficient. Here's how I'm going to do it. But I still want to charge a flat fee on this transaction. With that disclosed to you, are you okay with it? They sign off on it, I think you're good, right? But the rule is very careful. It just says that the fee doesn't need to be unreasonable. That's all it says. And then there's a number of factors that go into that: time spent, experience, that sort of complexity of the underlying matter. So the lawyer should disclose to the client the use of AI to the client, be transparent about the pricing, and be fair and reasonable in the fees. That's the duty that's incumbent on. Duty of candor. This is where a lot of litigation practitioners are getting in trouble with courts these days, right? So I know you've probably heard a story about a lawyer or a law firm getting sanctioned because they filed a brief that contains hallucinated cases or case citations. I think when I put these materials together a few months back, I found a statistic on this. I'm sure, I know since then it's happened more, but then the writer of the article said that for 508 lawyers and or law firms had been sanctioned by courts for the use of AI to prepare briefs, and they didn't check the facts with many cases and prevent those from getting filed. So it's becoming a major problem, especially on transactional attorneys are not exempt from that, right? So Rule 3.3 imposes upon a lawyer a duty of candor to the court or tribunal. A lawyer may not make a false statement of material fact or law, fail to disclose material fact when disclosure is necessary to avoid assisting criminal or fraudulent acts by the client, fail to disclose legal authority directly adverse to the client's position, or offer evidence the lawyer knows to be false, right? So again, if you're using AI to generate a brief for those real estate litigation practitioners in the room, you better make really sure that the output brief, the draft that it's giving you, doesn't contain hallucinated case citations. At some point, I think the courts are grappling with this right now, but I think at some point the courts are probably going to lose patience and say, we told you, you've had ample warning for a long time. And I think the sanctions are going to get potentially harsher. Yeah, so I included that. Since 2025, there have been 518 documented instances of lawyers filing pleadings with hallucinated cases. And of course, they can be sanctioned, face disciplinary action, and even be disbarred for the violation. So it's very serious. A lawyer who does not know how AI generated its false output fails to meet their ethical burden. And that comes directly from the state bar's generative AI. So that is clearly what this state bar's position is that if you don't know how AI works and you don't know how it generated false or incorrect outputs, then you've failed to satisfy your ethics. And finally, duty of supervision. Georgia Rules of Professional Conduct 5.1 and 5.3. Taken together, these rules require that a lawyer with managerial authority make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the lawyer or non-lawyer, their conduct is compliant with the rules of professional conduct. Partner or lawyer with managerial authority can be responsible for the junior attorneys or non-lawyers. So we're talking about AI, using AI to assist you in your practice. AI would be considered a non-lawyer, a non-attorney. You, as the managing partner, or manage a partner with managerial authority, are responsible for making sure that the AI applies with the rules of professional conduct. So you have that, because of that managerial responsibility, you must oversee the use of AI to make sure its use remains compliant with the conduct. Otherwise, these person can help. So that's pretty much it for the rules of professional conduct. The only thing I will say after that is if you don't have an AI use policy, you need one. Only 17% reported having an AI use policy governing its use. Here's the threat. You may have employees in your organization who are already using AI and exposing you to potential liability, ethical liability, right? So you need to adopt an AI use policy and spend some time thinking about what you want to govern and how your company should be using AI in an ethical way. That's it. Any questions? None. Questions? All right. Yes.
Good question, but just as a comment, there was a case that came out of the Southern District of New York a couple of days ago, and I believe that it said point blank, trying to find it, that client had submitted documentation into ChatGPT or some large language model like OpenAI. And in doing so, the court ruled that they had completely waived attorney-client privilege as to any information contained in there. And that even asking legal questions of AI waive any privilege that they had as to those legal questions, even when they went and are asked those same questions to an actual attorney. Wow. So not only should we be worried about this, but I think that it's prudent to warn your clients not to do it.
Yeah.
I know I've had clients who have submitted things that I've drafted for them. They just ran it through
Yes.
AI. Remind them why that's not a good idea.
Yeah, that's very true. And I saw the same case. I think it was on LinkedIn post. I saw it, and it honestly kind of blew me away with the ruling. That exposing that or giving that information, sharing that information outside of the clear line of communication with your attorney, and their staff, is a waiver of the attorney-client privilege. And yeah, I mean, 100%. I think you need to inform your clients that they don't need to be sharing information or using AI to analyze their own case. That's what they've hired you for, right? Like, you hired me for my expertise.
Or
Yes.
to write a contract, sent to you to.
Oh yeah, oh yeah, because they think they're going to save some money.
Yeah.
Yeah,
Like,
yeah, exactly. Now, granted,
some of them
that
are
may not
okay,
involve the
but
attorney-client privilege or confidential information necessarily from facts, but yeah, just from a general standpoint, using it to write a contract and send it to the attorney, I'm of the opinion it's going to cost you double at that point, right? Because I'm not only drafting a contract from something that I know that I trust, it's a template document, I'm now having to take a completely different document, review it for compliance with Georgia law specifically to make sure everything is in there, the rights and remedies that are afforded to parties are permitted by Georgia law, is consistent with Georgia law, all that stuff. It's going to take double the amount of time. So I think that conversation needs to be had. Fine, you hired me for a reason. You hired me for my expertise. Let me do my job. Don't Monday morning quarterback me with AI. Good question. Anything else? Yes.
Do you think we will have to use AI at some point in our profession in order to stay up, like keep up with other attorneys using it? Because you talked about like the flat rate question, right?
Yeah.
You know, we're charging $5,000 to do X task. Another attorney's going to charge $3,000 to do X task, and he's using AI. And I feel like there's kind of some questions that arise in that.
Yeah, that's a difficult question. If you're asking me personally, I think it's going to be very hard to be adopting the use of some kind of AI in your professional practice. The extent to which you adopt it and what it's used for, I think will vary greatly. You know, this gets back to the sort of the root of what is AI good at and what are humans good at. And we're going to see a shift of that sort of task-oriented, mechanical type stuff being handed over to AI, and humans being focused more on quality control, information verification, professional judgment, legal reasoning, analysis, which, let's face it, is what we go to law school, right? So the answer to your question is, yeah, I don't think AI is going anywhere, and I think it's really going to continue to be adopted more and more. Just don't know to what extent it's going to be used in the legal profession, specifically on the title side. I could see a use for it in document review, due diligence type stuff, for sure. As far as generating output, good question. Anyone else? Any other questions? Going once, going twice. Thank you so much. I appreciate your time. Hopefully you found it informative and entertaining. Thank you.
Office. Next up, we have Lachey Calloway with the Calloway Law Group. Lachey is going to be presenting on transfer on death deeds. This is another subject that if you are not aware of transfer on death deeds and where we are, really should pay attention. Lachey is going to give us that information.
Good afternoon, everyone. I'm gonna get an idea. How much does everyone know about the transfer on death deed? Like, is this the first time you're gonna see the code section and really get into it, or have you looked at it and you kind of understand what the statute says right now? You understand the current law. So, or this is the first time you've seen it and this is the first time you'll go through it, raise your hand. Okay, and then everybody else kind of has an idea about it, and especially the pitfalls. All right, so this particular presentation, we're gonna go through the statute, but we're gonna go through it at a higher level overview, just because it's already, this is what's here. We're working on getting it revised. And so there's a lot of information to give you today. I'm gonna switch around in one section and when we get there, so in the outline, we have transfer on debt. So we're gonna go over what it is, the code section review, like at a high level overview, high level summary, not ovaries, that's a different presentation. Review of pitfalls with the current statute, revision of which is HB 899, current legislative session, and that's going to be a brief summary, particularly because it's still happening, and potential title requirements with a Todd to consider, and then I'll leave time for questions and us to discuss more. So because this is the title standard seminar, I'm actually going to move section 6 up to number 3. So we're going to go through what is it, and then code section. I'm going to give you some things to consider, and then we'll get into the pitfalls and where the legislation is and what we revise, because that tends to be more of the discussion piece. And I do want you to get some of the title things to consider first, and I don't want to run out of time for that. Okay? Everybody with me so far? So again, I'm Lachey Calloway, and I handle real estate, probate, and estate planning. And so this is one of the reasons why when the statute was first released, I received questions from estate planners and probate attorneys like, well, what does this even mean for us? And how does that work with, real estate? And so that's how I kind of started doing research and ended up doing COEs for different groups to explain to them what the statute said. And then as we started doing more and more research, we understood there's some problems here. And so that's kind of how I became the quote-unquote expert on Todd's. I don't know that I would say that, but that's what you'll see on the listserv. So that's how we got here. All right. So what is it? So this is, as of July 1st, 2024, this was enacted. It's not retroactive. So I know some people have seen people that had Todd's prior to this date and tried. So if you see that in your title exam, don't use it. It's not enforceable, okay? But it allows property owners to transfer their property kind of like a pay on death beneficiary at a bank. You do it with a deed. So a lot of people use this for estate planning, giving it to their kids without losing their step up in basis, because this still is considered a testamentary gift. So they won't lose their step up in basis using this document, okay? So a grantor or a record owner will convey the property to his designated grantee beneficiary. He still retains the property, he or she still retains the property ownership the entire time until they pass away. And then once they pass away, the beneficiary or beneficiaries have 9 months to file an affidavit and a death certificate to claim the property if they want it. If they don't want it, it reverts to the estate. And within 9 months or sooner if someone says that they don't want it. Okay. All right, so it's not a life estate, because this is something that happens when you have a life estate. The owner doesn't have, the person that retained the life estate is no longer on title, so they're not able to do anything like get a refinance or anything like that. With a Todd, the owner still retains complete ownership. It's just it's like a springing power of attorney. This is a springing deed, right? And so it only becomes effective once the person passes away. It's not a ladybird deed. So ladybird deeds, transfer is not automatic. With ladybird deeds, they are automatic upon death. And this one is revocable. Ladybird deeds are not revocable. That's another thing that's very important to remember. And hours must be claimed with proper steps. Minors, this is not a great, and we all know this. Transferring real estate to minors is never a good idea. So this doesn't change that. Don't use a Todd to transfer to a minor either, okay? And it's not automatic. So as the statute currently stands, it's not automatic. All right, so code section review. So they created a new chapter within Title 44 specifically for transfer on debt fees. And it's found in chapter 17 and it's sections 1 through 17. Okay. So the first 44-17-1 actually provides the definitions of joint owner. So this is when you're thinking of somebody with joint tenants with rights or survivorship, that matters within this code section. If it's tenants in common, it's the same thing that we already know about, right? And it works the same way. So requirements. So if in 44-17-2, it provides the elements needed to effectively create a TOD, clarifies the beneficiary does not have to affirmatively accept this before the record owner dies for it to be valid, provides the steps the beneficiary must take to claim real estate provided in the TOD, and provides the 9-month deadline to claim the property. One of the reasons why I have this slide, and I know this is in the material, and I went ahead and gave summaries, is because you want to read, depending on what you're trying to do and what the TOD is, like, are you revoking it or are you creating one? You'll want to go to that section and read completely through. Unfortunately, there are some inconsistencies in the statute right now. So this is one of the reasons why I provided, here are the, if you're looking for this, go here. If you're looking for that, go here. So that's why it's laid out like this for you when you go back through your materials, if you need it, just as a quick guide, okay? So 44-17-3 provides the actual form. So you can go to the code section and it's a PDF, you can convert it to Word and do what you need to with it, right? And revocation or amendment is found in 44-17-4. It provides how the record owner can revoke a TOD anytime before their death, provides how the record owner can amend beneficiaries anytime before their death, and provides that a TOD cannot be revoked by provisions within a will. So that's important for us when we're looking at title exam and we have a probate estate and it had a will. If they said they revoked their TOD within the will, it's still ineffective, okay? And one thing going back to the form with 44-17-3, that's very important for us in title. This had to be filed before the owner dies. It's insufficient for it to just be signed and executed before they die. It has to be recorded. So when you're going to need that death certificate to confirm that it was actually filed before they died. Beneficiary rights, beneficiary predeceasing grantor, those sections are found in 44-17-5. Which provides the subject to meeting all the requirements in 44-17-2. A beneficiary takes interest in the property free and clear of claims from any subsequent spouses, but not free of liens, mortgages, etc. Also states that the liens of the beneficiary will attach after the affidavit is filed. So, petitions for your support. There's always a question of what does that mean? How does this impact it? So right now, it's silent on a petition, is silent on any spouses that the record owner had before they filed a TOD, okay? You don't know how that works yet. But it does say that if a record owner files a TOD now and then gets married the next day, the TOD will take priority and that grantee beneficiary will take priority over a subsequent spouse. So the way that it currently reads, a petition for your support by a spouse that was after the TOD was filed would not be able to take priority for that property. This does not say anything about the kids. So someone asked me yesterday, well, what about the kids that were alive before the TOD? Great question. Don't have that. It's not provided in here. So go to your underwriters is the short of it, right? That's if that comes up. So that's 44-17-5. The next one is 44-17-6. So when there's a joint owner, so joint owners with rights of survivorship. Very interesting here. Husband and wife can both do a transfer on death deed, but the only one that will control is whoever dies last. So whoever dies first, their beneficiary doesn't get it. Whoever dies last, their beneficiary will get it because it's joint tenants with rights of survivorship. That actually makes sense, right? Joint tenants with rights of survivorship. So whoever's the last one standing gets their Todd is what takes priority. And then 44-17-7 provides the limitations that a record owner who signs a Todd is still record owner with respect to creditors and purchasers until their death, right? So this is again what we said before, how this is different than a life estate. They still retain ownership. They can still do all the things that they would normally do, even though they filed a Todd, okay? So this is where I'm gonna skip to, we're gonna come back to the pitfalls. So I'm gonna go to this one. So potential title requirements with a Todd to consider. So since this was enacted in 2024, has anyone seen one come through their title yet or dealt with one yet? You did? Just one, okay. We're gonna come back to you. So potential title requirements. These are things that in my research, I had to kind of find out how other states and underwriters were treating this, right? And so these are things that I saw happening in other states, and I did hear a few things here in Georgia too. So this is something to keep in mind that you may have to request depending on what your underwriter says, because with a Todd at this point, and especially until the statute is amended, I would run all Todds by your underwriter when you see one, just to make sure that you have what they're going to want in order to insure over it. So if a transaction occurs within 3 years of the death of the record owner, a title company may require confirmation that nobody filed a petition for years support. We already went over, it's kind of silent on what happens for the spouses before the Todd was filed. So this is why they may require that. A determination whether the record owner had a spouse and or children. Again, petition for years support, beneficiaries, and heirs at law. If yes, confirmation that those parties are not challenging the Todd. Obviously, as you have with any probate matter, there can always be a claim for duress or undue influence. So that's why they're going to ask, are there any claims right now, especially in the probate record, right? Or challenging the Todd. An affidavit from someone other than the designated beneficiary who personally knew the record owner and can attest to being aware of the Todd. So they may want sort of like an affidavit of dissent, someone that can say, yeah, the record owner, I knew the record owner and he or she did this Todd and they were aware of what they were doing. So they, kind of defeating any claims of duress or undue influence. And then that the record owner willingly executed the deed and understood what they were signing at that time. May also require that they affirm there are no known contests to the Todd by any heirs. So just kind of keep this in the back of your mind. When you see a Todd come up and you reach out to your underwriter, they're probably going to ask questions like this. So you can already start working on getting that information for them to make it easier and for you to get through your closing process quicker. All right. If a transaction occurs within 3 years of the death of the record owner, continued, an exception for any debts of the estate because the designated beneficiary is not a BFP, it is possible that a creditor could pursue the property to satisfy their claim. We don't know if that will happen, but that's something to keep in mind because the designated beneficiary is not a BFP. Although HB 899's revision regarding unsecured debts may resolve this issue, there may be an unwillingness to insure over claims against the estate until there's case law confirming that Todd takes priority since Todds are new in Georgia. So, and we'll come back to HB 899, but just keep that in mind. They may still want an exception to federal estate taxes, and they may want payment of any liens against the record owner. Because the designated beneficiary does take subject to all the liens all the secured liens that are against the property. Okay.
Are you saying that like FIFAs that they may not be required to be paid after 3 years or something like that?
No, I'm saying that if your record owner died within 3 years.
Yeah.
And you're now doing the closing, and there's a 5A against that record owner, the title insurance company may require that to be paid.
Why is it only a possibility?
It's just, I can't say anything. I don't have a crystal ball, so I can't say exactly what they're going to say and what they're going to want for this. So secured liens are required. I mean, the designated beneficiary does take on those secured liens, but I'm not an underwriter, so I'm saying it could be what they want. I understand what you're saying. It seems like it's a definitive, and maybe they want to answer now and tell you yes, but I'm not going to step in their shoes and tell you yes.
Yeah, I can't think of any reason why we wouldn't require a 5A to be paid. I've not seen that it would be wiped out or.
Presumably would have to be recorded prior to
Right,
the designated beneficiary coming to title.
right.
So you're gonna have it anyway, like you're saying,
Right.
they'd always have to be paid to let things expire.
Yeah, okay.
All right, so if the transaction occurs after 3 years of the death of the record owner, a title company may require an affidavit, same affidavit from someone attesting that they did it their own volition, they knew what they were doing. May also require confirmation that all debts of the decedent's estate have been paid in full. Normally you get that when you're dealing with a will or even an administration. So, but with a TOD, that's not something that's necessarily required when the designated beneficiary gets the property. So that's one of the reasons why that may be required as an additional requirement with a TOD, because you would already get that if someone has done an administration of an estate. An exception for federal state taxes, that's never going to change. Payment of any liens against the record owner, same thing. And if the title company is uncomfortable with the provided facts, be prepared for a requirement to probate or administer the estate before it's willing to insure title. So we already know right now that if someone dies within 3 years and probate hasn't been done, it's required. So this probably won't be any different. And even if it's after 3 years and the estate hasn't been done, depending on the set of facts, they may still require probate. So that's just something to keep in mind, okay? Just as you're dealing with these. So now we're going back to pitfalls with the current statute. As I said, this one, there are inconsistencies in this statute, particularly because our statute is verbatim taken from Oklahoma statute. Okay, their transfer on death. There are things that Oklahoma allows for and doesn't allow for, or I should say that they allow for that we don't, or things that we need that they don't require. So that's one of the reasons why we have inconsistencies, and it doesn't necessarily conform with all of the ways that we have Georgia laws right now. Also know that the Oklahoma statute was not drafted by attorneys. They have a very large lobbyist group there that's very anti-attorney. And so this was how the Todd statute came about there. And that lobbyist group that's anti-attorney is the one that drafted this statute. And theirs was enacted in 2008. It went through 5 revisions since then. So that's another reason for inconsistencies. It's just kind of inherent, right? So I have in the materials the memo that I sent and circulated last year that had all the pitfalls and goes into really a lot of details about what we don't know, what happens in this situation, X, Y, Z. Here, we're just gonna hit the actual high level parts of it. So to show you, this is what we addressed with our revisions, okay? So acceptance, the way that it's written right now, it's unclear whether, if there are 3 designated beneficiaries, if one designated beneficiary has to accept it within 9 months and that counts for all 3 of them, or if they each individually have to do it. That's unclear right now in the statute. Unofficial witness, to revoke the current, and revocation with the current statute requires 2 unofficial witnesses and a notary. We don't require 2 unofficial witnesses for any deed with what we do right now. So it would be whether that's actually going to happen and people are going to remember to do that can cause problems. So if you see a revocation and as the current statute reads, and there's only one unofficial witness, run it by your underwriter because that technically doesn't comply with the way the current statute reads. And then that's with revocations, petitions for years support and Medicare liens. Again, this is silent on how that actually works and, you know, which one takes priority. PT 61s, there's no instruction in there right now about when you're supposed to do the PT 61. Ideally, it doesn't make any sense to do the PT 61 with the deed. You should do it with the affidavit because that's when it's actually transferring title. But it's silent in the statute, so this is why we have this as a pitfall. Personal representatives. Can an attorney in fact actually sign for this? Currently in the statute, it's a little unclear, but it doesn't seem like they're against it. They can do it. What I heard from, I did meet with the some panel members from the Oklahoma Title Standards Committee to go over their statute. That's where I'm getting a lot of this history and background. And so they told me that in Oklahoma, the only powers of attorney that can actually revoke or do anything with a TOD are the ones that have the enhanced powers. Like what we have, where in our statutory POA where it says they have the right to change a beneficiary designation. So those super enhanced powers, those are the only ones that can do that in Oklahoma. But the way that the statute is written, it doesn't make that clear that that's what Oklahoma does. So that's why it's ambiguous for us, right now. So like I said, powers of attorney, death of a beneficiary during the acceptance period. The way that it's currently written, we don't know what happens to that share. Does it revert back to the estate? Does it go to the other beneficiaries equally? It's silent. Death of a beneficiary when there are multiple beneficiaries, the same thing. Well, regardless of whether it's an acceptance period or before, what happens with that share is, does it go to the estate? Same questions. Designating alternate beneficiaries when within the deed, the way that it's currently written, it's silent. We don't know if you can do that or not. A lot of people that are doing this and using it as an estate planning tool, that's something that they're accustomed to doing, which is why this question came up. Can we do this with this transfer on death deed? Because I can do it if I did a will or if I did a trust. So do I have that same capability? And then can a trust be a beneficiary of a transfer on death deed or trustee really? But again, silent, we have no idea. Death certificates. So one of the requirements is that you file a death certificate with the affidavit, but if the designated beneficiary is a non-family member, how do they get a copy of the certified copy of the death certificate? Acceptance when a beneficiary is a minor. Again, no idea how that works. We know what we will need or require, but we don't know how that will actually work. And the statute is currently silent on, can certain defects be cured after the 9-month period? That's something that we probably want to know, especially for clearing title, but we don't. The statute doesn't tell us right now. So for the amendment that I to the bill, or the bill that I authored to amend the current statute is HB 899. Most of you saw this on the listserv. Last year, I circulated it and said, here's what we let me know if you have any edits, concerns, questions. I'm taking, all advice. And because I handle estate planning and probate as well, I did reach out to elder law section and the fiduciary law sections as well to get their input on revising this bill so it could work for all of us and address some concerns. So high level summary of what we did, what we added to address all of those. We resolved the issues with the death certificate. We have the clarification on when title transfers throughout the statute. So right now, at the very beginning, it says it title only transfers within 9 months, or I'm sorry, title only transfers once someone accepts within 9 months. But then in another part of the statute, it says title transfers automatically. But that inconsistency was actually resolved, so it stays consistent. It's after the 9-month acceptance period. PT 61s, we actually already worked with the Clerk's Authority. We already got this approval from the Superior Court Clerks of Georgia. PT 61s will be filed, as long as this passes, will be filed with the affidavit only. And so when you have the transfer on death deed, the Clerk's Authority has already done a drop down where it will not require a PT 61 to file a transfer on death deed. It's actually going to ask, is this a transfer on death deed? And if you say yes, there's no PT 61 required. That resolves all the frustration on both ends about when a PT 61 should be filed and resolving the issues of the blowback that has caused thus far. And then when they file the affidavit, it will say an affidavit in connection with the transfer on death deed, and then it is a requirement for a PT 61. So they made it very clean and easy for us, and they've already done the parts in their programming. So as soon as this is passed and, to the extent it's passed and it is enacted in July of this year, that will already be ready to go. This allows for alternate beneficiaries within the deed, confirms the right to transfer to the trustee of express trusts, confirms a record owner cannot create an express trust with this instrument, confirms capacity standards. So as many of you know, the capacity that you need to do a will is much lower than what you need to actually execute a deed. So we made it where, since this is a deed, that they need to have the same capacity as they would to execute a contract. So we kept it consistent with what we normally do, instead of the lower threshold as you need to create a will. And then we also confirmed that a POA cannot draft a TOD. So no one was really comfortable with that, regardless of whether they had the enhanced powers or not. That is completely eliminated with our amendment. And 44-17 2C. So we didn't add any additional sections. We just added subsections to what was already there. So it's still, when we finish, if our bill is approved, it will still only be 44-17(1) through 44-17(7). There are just more subsections within it now. Acceptance, we confirmed that it can only be one person that can accept on behalf of themselves. And then, or if they are a guardian or conservator, they can accept for the ward or a minor, a trustee. If it was left to an LLC, then someone who's the managing member can do that, but we made that pretty clear. 44-17 2D reinforces what each beneficiary has to do to claim their interest. So it just lays out exactly they need to provide the death certificate and affidavit, all of the things to claim it within the 9 months. Use of a PT 61 to file the affidavit. We went over that part to accept. What happens for acceptance for multiple beneficiaries prior to July 1st, 2026? Because this statute has been in place and will have been in place for 2 years, we just said that if there were multiple beneficiaries and one person accepted on behalf of everyone within those 9 months, we're going to allow that, but you still need to run it by your underwriter just to make sure that they are going to say the same thing, or if they're going to want anything additional. But because this is how the current statute reads, it would be kind of hard to tell them, no, you were supposed to each individually accept retroactively. So 44-17-2G, requirement for personal representatives to provide notice to designated beneficiaries of the pod. So one of the biggest questions and concerns was, well, how is someone supposed to know that they're a designated beneficiary, especially if they're not a family member? And so what we put in was, what the initial one was, once someone, within 45 days of becoming a personal representative, They are the same way they have to do the notice to creditors, they have to put the heirs at law and beneficiaries, if there's a will, on notice of the death. That they also need to run title and find out if there's a Todd and then notify designated beneficiaries. You add that within 45 days, they need to notify the designated beneficiaries that so the person has died, their property was left to them, and they have 9 months from when the record owner died to claim it, right? And they can refer them to the statute. The fiduciary law section did not like, I shouldn't say the section, but the fiduciary law attorneys did not like the 45-day requirement. And so they wanted it to be consistent with another statute that gives personal representatives 6 months to do it within 6 months. So in order to appease them and get, a uniform bill to the House of Representatives, we went ahead and said, okay, so it's citing that code section now where a personal representative has 6 months, within 6 months of getting appointed, to provide notice to everyone. They didn't want a special carve out for Todd beneficiaries when everyone else is only entitled to 6 months with, notice within 6 months. That was really their biggest concern. Let's see. So we provided the requirement of notice, but we also provided options for personal representatives to handle ways for them to handle the property if they haven't heard anything from the designated beneficiaries. And if it's a solvent estate and the mortgage, is about to go into foreclosure, or there's damage to the property, some hurricane blows through and something needs to happen with the property imminently, this gives them a way to handle that and also get repaid for it. And so it's mechanics lien type of recourse that we put in the statute for them. And it's optional. If they don't want to, they're not required to, but they do have that option if they want to preserve the property. Because one of the concerns was, okay, as a fiduciary, as the personal representative, you are supposed to protect the assets of the estate. And what if someone doesn't accept in 9 months and you let the house go into foreclosure, or you let all these code violations pile up to, $30,000 like we have seen? When it could have been handled because there was money in the estate. So understood that's a valid concern. So they have this option. In the alternative, if it's an insolvent estate, then they are able to, there's another option for them to put the designated beneficiary on notice and say that we are exercising this part of the statute. You have 4 months to claim it, but we have, as the estate, we have to take over and it reverts to the estate in 4 months with that, just so they can handle it, because they don't need something to sit out there for 9 months if someone isn't going to accept within 9 months. Again, it's an option, it's not a requirement, but it gives a little more flexibility for the person, for the estates. We also added which defects can be cured after 9 months. So essentially, what they have to do in 9 months is file that affidavit and the death certificate. If they get anything else wrong, we can do that, kind of how we get an affidavit of descent, or when someone is joint tenants with rights or survivorship, we put a recital in the deed. This person died, they own it, this person died. And so we can do that with closing, but those two things have to be done in order for it to be the Todd to be effective. We
Lachey,
also removed.
on the personal representative giving notice to the beneficiaries,
Mhm.
weren't we using the Todd to avoid probate in a lot of instances?
Yes, you were, but it still reverts to probate if someone doesn't accept, which is why.
Understood. Okay, understood. Thank you.
So we also removed the authority of an attorney in fact to revoke a Todd. So again, everything that had to do with the power of attorney, it's eliminated. Clarifies that only one witness is needed to revoke. So that's consistent with what we already have and how we operate. Removes the ability to revoke within the context of another deed. We didn't want a line in a security deed added saying, by the way, I also revoke this up because we're gonna miss that. That's overly burdensome. If it's done in the context of another deed instead of an actual deed. We also confirmed all the actions that can revoke a TOD. So right now, if a record owner has a TOD filed, but then they decide they want to transfer their property to their own express trust, like a revocable living trust or irrevocable, that will revoke the TOD. Because now they're saying that they want this to happen per the terms of their trust, as opposed to the TOD. And then there are all the other ways that they can revoke a TOD. So that's what this subsection handles. And then when we get to 44-17-5A.
Lachey,
Mhm.
sorry, so if this removes the authority of an attorney in fact to revoke a TOD,
Mhm.
but you're using an attorney in fact to possibly sell the property, do they not have to revoke it to sell it?
They don't. No, the actual selling of the property revokes it in and of itself by operation of
But
law.
if they don't have authority to revoke it,
No, meaning the actual sale of the property. So it doesn't matter. They're an attorney in fact. So the actual record owner is selling the property, not the attorney in fact, right?
right?
That's why it's not the attorney in fact revoking it. It's the actual sale, the deed of transferring it to the buyer is what revokes the TOD.
You don't expect to see any litigation on that?
It's actually laid out, like I gave you guys a high level summary, but it actually says selling a property revokes the TOD. That's actually listed.
Even a sale with using an attorney in fact?
Remember, the record owner is the one that's selling it, not the attorney in fact.
Okay, I've seen litigation on that in Texas.
Okay. So you guys can be aware.
Suggestion.
Write it down.
Away from Texas.
Yeah,
Write that in.
if you're in there rewriting, it's just a suggestion.
Yeah, no, we're too late for us at this point, but you know, there may be further, depending on how everything goes. Yeah, it says if the property is sold, then it revokes it revokes a TOD, when you sell it to another person.
Lachey,
Yes,
can an executor, once the grantor is deceased,
yes.
can the executor revoke the TOD before it's accepted?
The executor has no authority over the TOD because until it's unaccepted, it's not a part of the probate estate.
Thank you.
So for 44-17-5A confirms that title transfers after acceptance. And it confirms TODs take priority over unsecured debts. And, was removed, no longer over a petition for year support. So one of the earlier versions, and this has evolved since last year, we were going to make it consistent with what it already says about additional spouses. So we were like, okay, well, apparently they want a TOD to take priority over a petition for year support. The legislators were not happy with that at all. And then that now is removed. We are not at this juncture, we're not putting that in the bill. There will be further edits to the bill in other sessions. And I know they're going to focus on a petition for year support specifically, but the way that the legislators are wanting to do right now, they want to preserve all aspects of petitions for year support. They don't want anything to take priority over it. They want to keep that protection for spouses and minor children. So the further edit to this bill will confirm that motivation and that goal, but just not within the context of ours right now. Let's see. So OCGA 44-17-5B explains what happens to lapsed interests. So beneficiaries who die after the record owner but before acceptance, a few things can happen. It's going to take a lot for it to revert to the estate, and it's really just if no one accepts. So right now, the way the statute reads, if the designated beneficiary predeceases the grantor, then the TOD is rendered revoked by operation of law because they're no longer here. And that's if it's a sole designated beneficiary. If there are multiple designated beneficiaries and one of them dies before the record owner, then if it was like, say, 3 people were listed as designated beneficiaries and one of the 3 predeceases the record owner, then now the 2 remaining designated beneficiaries will take it 50-50 instead of a third. So it gets absorbed by the remaining designated beneficiaries unless, and the grantor has the option to do this now, well, I'm sorry, with our amendment, that they can designate an alternate designated beneficiary if someone predeceases them or they die during the acceptance period before they accept. So attorneys in fact cannot accept on behalf of a deceased designated beneficiary, right? Attorneys in, well, no, obviously it can't be an attorney in fact, but an executor or a personal representative cannot accept on behalf of deceased designated beneficiary. So this is someone who dies after the record owner, but before they had a chance to accept, their interest also lapses and it either goes to the other alternate beneficiaries, their share, or it goes to the group of their designated beneficiaries that they were in. So either the alternate or just gets absorbed by the other people that were also listed with them. And then obviously if no one ever accepts, then it goes back to the estate. So since each individual designated beneficiary has to accept, and if there were 3 beneficiaries and only 2 of them accepted, then that means the third reverts back to the estate. Okay, does that make sense? All right. For the petition for year support, based on the way the current statute reads, they have added a line that says subject to OCGA 44-17-5A. And then it goes into the regular language for a petition for year support. And that was just making it clear that as the statute currently reads, spouses subsequent to a filed TOD are subject to a TOD in the designated beneficiary. So legislative council just wanted to make sure that everything kind of lined up with what we already have out there. So this was their added addition. We also added a code section that says for death certificates, the actual code section, we said also designated beneficiaries within a TOD can get a certified copy of the death certificate to satisfy their requirements to accept a TOD. So those were the 2 code sections that were edited in addition to Title 44, the transfer on death deed statute. So current legislative session started January 12th, 2026 and ends April 2nd, 2026. HB 899 was assigned to the House Judiciary Committee. The House Judiciary Committee hearing for the bill was held a few times. So it was first held on Monday, and then we sat there all day, and then it got postponed to Wednesday, yesterday. We went there and it was canceled, and now it's going to happen on Monday. So happen on Monday, right? Anyway, and so March 2nd. So we're waiting to have that hearing so that we can actually get this passed. So, well, I should say get it approved in the House. Crossover date is next week. So, we're running up against the clock. Exactly. So we want to make sure that we actually have this hearing. And it was very interesting. The bill that was in front of ours, I was actually surprised that they spent as long as they did on it, because it seemed like, it ate up the clock, and it didn't seem like it was ready to go yet. So why did the rest of us have to wait for something, for them to work through it? But I appreciate they were really trying to help these people out and do all the amendments to so theirs could get passed as well. All right, we already went through the requirements, so questions and discussion. Yes.
You know I was gonna do it. Have you thought about doing a distinction between the 2024 bill and 2026 bill if it gets passed? In terms of like reverter and a security deed, that there be 2 separate standards set for the 2024, or is the 2026 gonna say retroactively everything from 2024 is factored into it, so to speak?
With respect to what on a security deed?
Well, like when you do security reverter, the date of the security tells you if it's 20 years or it's 7 years, et cetera.
Mhm.
So you got a 2024 bill that didn't provide for all of everything the 2026 did.
Mhm.
Are you thinking about making it all 2026, or there'll be a separation between 24 and 26?
So with respect, most of the things that are in, and I think that's more of an underwriter question, so you might want to answer, or, but one thing that we did account for was whether a designated beneficiary could accept for everyone or just themselves. And that's already in there, what happens prior to July 1st, 2026, because that would have been when it was accepted. I believe the way that the Georgia Constitution reads is pretty much, if we get something on title and we see that it was, certain things were done or the way that it was done, like if we get something now and it was a revocation, but it only had one unofficial witness, we would have to look at the date, because I don't think that anything that's enacted as July 1st, 2026 is not going to be retroactive to apply to what was happening before. They did everything. We have to apply the laws that were happening between 2024 to.
And then the second question.
Mhm.
You're asking, the title company may ask for an individual to sign something saying that the person knew what they were signing at the time. My parents have a trust. I have no clue what's in it. I'm not allowed to look at it until they pass.
Mhm.
So I don't know how we're going to get an individual, like I can't just walk down the street and say, is your house in joint tenancy or is it individually? I just think can we do a self-affirming affidavit attached to the?
Well, it would be hard to get a self-proving affidavit when someone is already dead, right?
No, I mean, when they do the TOD. When they
When they do
execute
the
the
TOD.
deed,
So
sort of like wills.
I know, but here's the difference. So when you have a will, and even though people do self-proving affidavits, you still can go to the probate court and do a caveat saying, no, there was undue influence, there was duress and all of these other things. And because we don't have that natural recourse already built in, I don't know that the self-proving affidavit is going to do anything. But getting someone to say that they signed a deed, and they knew what they were doing is kind of like what we do with the with the affidavits of descent. We
Sure.
get someone who knew them, attests to, I knew this person, this is how I knew them, these were their children, but this is something that as practitioners, if you're helping someone with a TOD, you want to tell them to make sure that they, talk to someone and let them know
Got
that
it.
they're doing it,
That's a good
because
idea.
that way that person can attest to it. Another thing that as a tip that I typically say, one, TODs are so new here, and even with all the amendments that would make it better, I would still use them in very limited instances. I wouldn't start using them as, this is just what we do and we specialize in this, and this is the greatest thing ever, because it still has issues, just inherent issues being a TOD, right? And so, but you want to make sure that someone knows that you're doing it, right? Two, even though a lot of them a lot of the record owners don't want to tell the designated beneficiaries outright, because one, it's revocable. So it's like, okay, yes, I left it to my best friend, but then 20 years from now, we're no longer best friends. And I don't want to have to provide notice that I'm revoking it from, to that non-best friend anymore. But a good practice tip is tell them to put something in writing. I think of the movies Back to the Future where, like when he teleports back to whatever time period, somebody brings him an envelope and it says, go here and do this in that time. Same thing. Like leave it in your safe, a safe deposit box, in your estate planning binder, something where there's and you've entrusted someone to get it to your designated beneficiary. So when you pass, that designated beneficiary gets noticed immediately, but you don't have to worry about telling them before you pass. So that's one of the practice tips that I've told people if you're going to do it. But again, I would also, so those two things are really important. And then also, personal representatives aren't really in the business of doing title searches right now. But based on this, I highly recommend that they do that. Any other questions? No?
So we have, or the revised, statutes will provide for what happens, what needs to go, we follow someone steps here. You know. Another recipient revokes and it changes the percentage. How does that like to affect? Is that, would that affect the value that's stated?
So the value, it's a deed of gift.
Okay.
Yep, so there's no value given. But I'm trying to, so if you're saying if someone not revokes, but they just don't accept later on, like, so if there were 3 designated beneficiaries and 1 accepts, so 2 accept before the 9 months, but the 3rd one doesn't?
Yeah.
But it's a deed of gift, so it doesn't have a monetary value.
Okay.
Yeah, it's still considered as a deed of gift, which is why they, if it's, you know, if they're able to get the step up in basis, this doesn't change that.
All right. Next up, we have Carol Clark with Carol Clark Law.
Hello, everybody. Can you hear me okay?
Yes.
Everybody in the back? Well, LaShaw, you did an outstanding job on that. Oh my gosh, I came in and just looking at the summary there, I'm like, I didn't know Todd had a pet or that it needed a year's support. So it's, I know it's a great topic. So listen, you guys are here for your hours ethics credit. And we're small enough that I hope we can have a little bit of interaction. Ethics can be a very boring topic, but I want us to approach it today a little bit more personally. And I've called it, what's your name? What is your name? And I started thinking about this a while back. I'm actually going to be doing a Sunday school lesson for an older group at my church Sunday. And I was thinking about if nobody knew that your name was Shay or your name was Amy or your name was whatever your name is, and they just had to describe you by your most important characteristic, what would your name be? And I think it's an interesting idea to say, how are we known in the community? And you could think of it in any number of ways. You could think of it like the fruits of the spirit. You'd be known as patience, not this group, but somebody might be, or goodness or kindness or faithfulness or loyalty. But what would your name be? And in today's context, I want us to think of it is when you think of somebody who says, do you know so-and-so a lawyer? And you think of that person, is your first thought, yes, they're a good lawyer, a good ethical lawyer, or do you think, stay away? So what is your name? Are you known as an ethical lawyer? And that's kind of the approach we're going to take today. It's why do we need to talk about this? Well, not picking on any particular practice group, but every corner has a new billboard since we took up advertising, and we don't know each other the way that we did when I started practicing. You guys will get a kick out of this. My boyfriend just took me to the beach last week to celebrate birthday 75. Whoa. So that means that this year I will be in practice 50 years. So, and I'm still enjoying it. That's the great thing about it. So you can't get rid of me that easily, I guess. But in that time period, I have experienced a lot of situations where lawyers were not ethical, and we've dealt with defalcation, we've dealt with fraud, we've dealt with so many different kinds of problems. And that is why we now have ethics and professionalism. So I want to give you your hour's worth, but I also want you to help me as we talk through some of these issues. And even though we're a small room, we're probably recording this, so I'll make sure that we repeat the question. So to me, like I said, I'm old enough to remember when Walt Disney started coming on TV and when it came out in color. That was a big deal. And one of the characters in Disney was a little tiny item with a top hat and a cane. Does anybody know who I'm talking about? Who am I talking about?
Jiminy Cricket.
Jiminy Cricket. Jiminy Cricket. And what a great little thing for kids to learn. Jiminy Cricket. And what was Jiminy Cricket's motto? Let your conscience be your guide. And he had a little tune to it, let your conscience be your guide. I will not attempt to sing it for you. That is not in my group of abilities. I can't sing, but it doesn't stop me. But you don't want to hear that. But if you just think about a little Jiminy Cricket as a metaphor for kids to think, well, let your conscience be your guide. I think one of the issues that we're dealing with in this particular environment, certainly in our country being so divided, is that we seem to have separated ourselves somehow from our conscience. We tend to say, my conscience is red or blue or purple or affiliated with something, and that then reflects back to us what my beliefs are. So today I want us to stress and think about our individual roles, not only as lawyers, but in society, to speak up for the rule of law, whatever color your party is or isn't, or if you don't even belong to a party. So it's not a political speech, but it is not letting the divisiveness of our country define our own excellent ethical standards. So I want us to be aspirational about that today. So I know we have gone to this 1 hour of ethics, and in 1 hour of ethics, I cannot change how you approach your practice, or I cannot tell you what to do, nor would I. But I hope in this hour we can together just think for a moment about how we can set a more ethical environment around us. Because whatever you are radiating, your people in your office are going to pick up on that. And you are setting the standard wherever you are, whether you're underwriting, whether you're closing, whether you're litigating. People are looking to you as a leader, and you don't even realize it sometimes. But everybody is looking up to you in some way or other, and you want to be a model of your own aspiration. So one of the questions I want you to think with me about today is not only what anybody would say your name is, but what would you want your name to be? If you went by a name that was your strongest characteristics, what would you want your name to be? Aspirationally, how can we be our best selves as lawyers and as individuals? So one of the things that we can think about is how to approach the topic. Now, I don't know if you are aware of this. In doing some research on this a while back, I learned that there are all kinds of different philosophies of ethics and studies of ethics, and ethics has got so many books and schools of thought on it now. There seem to be really 3 different ones now. They're called meta ethics, meta like what we know as meta now, normative ethics, and applied ethics. So when we think about meta ethics, we're thinking about, oh, the whole universe, the grand scheme of the world. How do we fit into whatever our belief system is? Is there a universe? Is there a universal source? What is the meaning of life? Very supernatural. And that has an area which is, how do we get moral concepts out of that? Does it come from a particular tenet of beliefs? Does it come from something that's innate in us, in humans? I don't know if any of you saw this little clip in the last couple of days, but did anybody see anything about that little monkey Punch? Anybody see Punch the monkey? Punch the monkey is this darling little monkey who somehow or other got whatever he did, his mother won't have, as we say, she won't have nothing to do with it. And his mother abandoned him, and so therefore the rest of the troop abandoned him, and they're in a zoo. I don't remember what zoo it is, but anyway, and so somebody had the great idea, because little Punch was so lonely, they got him a big old, about this big stuffed orangutan. And if you look on your clips, and you'll enjoy this, doing this later, or if you get bored, you can do it while I'm speaking, it won't bother me. But you can look up, here's Punch dragging around this orangutan and holding the orangutan so close to him and cuddling up with this orangutan. And you think, well, yes, this is definitely who we came from, because we are social creatures. We look to each other for reflection. And pretty soon, because of this orangutan, a stuffed orangutan, the zookeeper started noticing that, hey, little Punch was doing a little better, getting along better with his colleagues. Next thing you know, they're all picking at each other and grooming each other and sitting by each other just like they do. So We are very social creatures and we haven't fallen far from that part of our tree. So how do we define ourselves in this society, in this world? Well, meta morals or meta ethics is one of them. The second one is called normative ethics, and that means like, what's everybody else doing? What is expected of me? And in this case, today we'll be talking about that in the context of two things: our professional rules of conduct and also the title standards, which all have been discussing. But normative ethics are what is expected of you, what is the normal, and hasn't that actually been incorporated into our entire common law? What is the standard of care? What is reasonable and customary? That would be an example of normative ethics. And here we have guardrails because our professional rules of conduct give us what those normative ethics are. Got the guardrails. If you're in here, okay, but if you get way out of here or way out of here, we have disciplinary rules to help you get back in the fold. The third area is called applied ethics. And I think this is probably self-explanatory, but it's like, okay, we know all this. Maybe it's ethics from faith or, you know, what's happening out in the world, or maybe it's normative, but how do we apply it for ourselves individually? Now, when I was growing up, there was a very popular book called Situation Ethics, and it was a new concept at the time. Oh, and it was banned in some places. Oh, we can't have situation ethics. There are ethics. There's right and there's wrong. Well, look how far our whole world has come from right or wrong. We don't have this is right and this is wrong. You know, yes, it's wrong to kill somebody, but what if they're trying to kill you and your family right there? I mean, we have all these gray areas now that make things less defined. How do we know what to do? How do we know what to do? So one of the funny definitions I found of morality says, well, and this Louis Grizzard should have said this, but he didn't. You know what Louis Grizzard said about telling the difference between, you know, whether you have clothes on or not. He says there's two different things. There's naked, means you have no clothes on, or there's naked, it means you have no clothes on and you're up to something. So this kind of concept, that's one of my favorite Grizzard lines. Are any of you young enough that you don't know the great Louis Grizzard? Okay, Louis Grizzard was a Georgia treasure. And I insist that you go online and find some of his books. He was a columnist, a sports columnist for the Atlanta Journal-Constitution, but he became known for his hilarious comedy. And he began doing stand-up before we even knew what stand-up was. And his books are just hysterical. Even if you just read them to yourself, you will laugh out loud. That was one of his famous things. But he had all kind of books. He got a pig valve one time for his heart. True enough, as an experiment at Emory, and he had a whole book about that. So Louis Grizzard is a treasure, Grizzard, and you'll call me and thank me after you find one of his books. But he said morality is the difference between what's right and what you can get away with. That sounds like that would be something he would have said. But we don't want to just get away with things. We don't want to skate on that fine, thin line. We want to be solidly within the rails of what we think is right, what our normative ethics think are right, and what ties us into our greater ethics, whether it's faith or family beliefs or reputation in the community. And when we say, what is your name? Thinking about your reputation in your own firm. Can people trust you? Are you loyal? Can you be counted on? Are you reliable? All of these kinds of things are part of a greater code of ethics and thinking about what we want to aspire to. Now, plenty of people have sort of lost their purpose. And one of the things that concerns me in our profession in general is I can't tell you how many lawyers have told their children, whatever you do, don't be a lawyer. Really? I mean, do you not want to be a lawyer? If you don't want to be a lawyer, if there's anyone here who is unhappy with your profession, please get your resume together, go back to school and do something else. Our profession is a wonderful profession of service. We are able to give service to others. We're able to help people when they really need help. And the reason I think I have enjoyed real estate litigation so much is for most of us, piece of property, a little piece of dirt. You remember in law school, they picked up the dirt and they said, you are season of this. This is how we got the title to start with. You got a big plot of dirt. This is your dirt. Well, that is for most of us our most important asset. Now, I know the stock market's over 50,000 and most of you probably are much smarter than I about how to buy and sell and trade on Robinhood and all that stuff. But for most people, buying a piece of property, letting that property appreciate, enjoying the tax benefits is the most important asset. So when somebody's in trouble with that asset, somebody's trying to wrongfully foreclose on it, somebody is taking out a predatory mortgage on it, somebody can't get straightened out with their title, all these things that y'all have just talked about with Lachey, it's important. It's a calling. And if it's not your calling, no problem. Pick something that is. Find something that you're passionate about, that you can bring all of yourself, your ethics, everything to, so that you will be your most fulfilled person. So as lawyers, we have to figure out, well, what really is right. And of course, you say that, Carol, but you're trained in law school to look at all the sides. In mid-court, you're an advocate for, an advocate against, like the Hatfields and McCoys used to be. They even settled their differences. Did you know that? They finally settled. Some of you don't even know who the Hatfields and McCoys are, but it was a real family, and they fought for years. They killed one another. One killed this one killed that one. It was different, that, different, that. And finally, it was a mountain family. They finally worked it out. But they are legendary. It's the Hatfields and the McCoys were about the worst you could do, but they would never end. And the feud went through multiple generations. So when we're looking at now how we're going to be taught, you're taking this side of it and you're taking this side of it. Who's right? Which is right? Ethically, which is right? Oh, well, if you're the advocate, you say my side's right. If you're the adversary, you say, oh no, my side's right. So part of this whole dilemma when we think about ethics is really trying to understand what the different points of view are. And then I think this is one reason I really enjoy doing mediation, because in mediation, it's not so much about picking a side as collaborating to figure out what's best for everyone. And that's one thing I really like about being the mediator, helping people see that you don't have to keep spending all this money and you don't have to keep fighting because of principle or because of standing in the community or because of pride. You can find a solution that accomplishes all of those things. And that also comes into our general belief system about having it be black or white, right or wrong. Now, I know many of you by now probably have taken some of those personality tests where you've got all the squares. All of you have done that, right? Somewhere along the way, where you have to figure out whether you're whatever they call them, colors, visionaries, whatever. They have different names for it. But the bottom line is that we have understood that we see the world differently. You can be a great person, great ethical person, but you can see the situation differently. So part of ethics in talking about today, title standards, has to be having a sense of, I'm going to call it curiosity, to understand, ask, what is it that this other person is saying about the fence, the boundary line, the encroachment, the whatever it is. And we see all kinds of things. I just have to say, one of my most recent cases that I am trying to just quietly get rid of, and maybe some of you represent this HOA, if you do, see me afterwards. We've got an 84-year-old mother, and 84 years is right on everybody's mind because of Nancy Guthrie. An 84-year-old lady took pity on these stray cats in her association and fed them. To date, they have fined her over $25,000 in her house because she fed the stray cats. Come on, people. What is right? What is not right? How is that ethical? It says so in the bylaws, you can't leave out food. This very rigid, ritualistic, legalistic reading has got to stop. We have got to bring our whole selves to the situations before us. We have to bring our whole self to step into it and try to say, what is driving this? Where is the understanding? And of course, if you've represented any HOAs, as we say, for or again, you know, a lot of people who are officers in HOAs have never had any kind of leadership role for it. You're the HOA president or something, you are somebody, and you're gonna do it the way I say. And, you know, you start enforcing a rule not to leave food out and read it as you can't feed a starving animal. I don't know what to say. Anyway, I digress. I've got to solve that problem myself and try to get rid of this lien. This HOA is filing a lien against this one. They're gonna try to take our house over. So, anyway. This is what we're looking at when we're trying to look between the lines. We think it's black or white. Very few things are black and white. And let me just say, the older you get, the more you understand that. There's so much gray and shades of gray. And I'm not talking about 50 shades of gray now. I'm talking about just gray. So I think the way that we are going to approach this today, first of all, is to think about what our professional rules say, because that's what we're going by. And as I said, this is an example of normative ethics. What is expected of us? And we don't have to guess, it's specified. Most people haven't looked at the professional rules of conduct in a long time. They're in your materials, but we're just going to talk about some of them. The first one is that the lawyer is a representative of clients, an officer of the legal system, and a citizen having special responsibility for the quality of justice. Now, I don't know what you think about this, but it's very hard to have special responsibility for the quality of justice in today's political environment, because people are so divisive. People think the Justice Department should do this. The people think it is illegal for the Justice Department to do this. There are people who think it's okay to bomb the ships in Venezuela. I had a client tell me just yesterday that that was absolutely legal. His son had committed suicide over fentanyl. He overdosed with it. And I have other people say, you know, isn't that a violation of international rules of law? These are real issues. Now, what does that mean for each of us? You can't stand up every day and say, you're right, you're right, you're wrong. You're right, you're wrong. And if you did, given our current environment, it can be dangerous. It can be dangerous. It doesn't mean we shouldn't speak up. It shouldn't mean that we in our own capacity shouldn't really follow the rule of law. We took an oath to uphold the Constitution. Now, we may differ on that. In the old days, when we were a true democracy and republic and people debated and they said, my position is this, yours is this, let's come together and solve something, it was not so much an issue. But all of you, especially you younger people, are going to have to deal with this for your lives. And I hope some of you will consider holding your nose and getting into politics so that you can stand up for the law. Because if we don't have the rule of law, we're not going to survive as a country. And there's no guarantee. Look at Rome. But anyway, so we are a representative and an officer of the legal system and how we function with that. So I ask you, and in my materials, I've left a blank. What can we do to fulfill our special responsibility to the quality of justice? If anybody has a couple of words they'd like to shout out, shout them out. You will not be shamed. Well, this is part of the problem. We don't really know what to do. We don't really know what to do. I have friends who have really chastised me for not protesting some of the things that happened last year. I did not protest. I applaud those who are speaking up for what they believe. I applaud them. But I'm saying these are individual ethical decisions that we all have to think about. How are we going to support the rule of law? And I've been thinking about this. I've been thinking that we need to really try to lobby for, maybe we'll get Lachey's team involved with her lobbying. But I think we need to try to get civics back in school so that people understand. Most people don't even understand how our country works anymore. And I don't know how it got taken out. I don't personally have kids, so I wasn't really aware of this until recent years. What can I personally do to improve the quality of justice? Now, I think there are some things you can think of there. Anybody want to shout out something that you can think of? Anybody ever serve on a volunteer lawyer or pro bono? You know, there are people, raise your hand if you've ever done pro bono work. Good. Well, there's more room for the rest of us to do more pro bono work, isn't there? I mean, it's not a matter of pro bono just being people who don't pay us. I mean, there are always plenty of that pro bono work. But trying to think about getting more legal resources to people who really can. Big law firms are expensive, hourly rates are high. And some of you are with larger firms, and I was told yesterday that one of the larger firms is charging, in New York is charging $5,000 an hour. You know, that's a high legal rate. I don't know anyone personally who has that rate, but if you do, you know, maybe you need another lawyer. Anyway, and then the second part of it is, as a representative of clients, a lawyer performs various functions. Well, duh. As advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. This is never more important than in our particular practice area because of what I said, because the value of somebody's asset is in this real estate. You've got to tell them what this means, how it's going to work. As an advocate, a lawyer zealously asserts the conflict's position under the rules of the adversary system. Now, when we talk in just a few minutes, as we are, about particular title standards, this is very hard because you've got to figure out the intersection of a potential conflict of interest. We wear lots of hats. Anybody who is in real estate, probably, or especially in closing, you have a title agency. You've got to intersect the abilities between who you represent and the title agency and the title insurer. And one of the issues that always routinely comes up if you're doing title insurance litigation is, you know, who do you represent? Well, of course, you represent the client, but you're paid by the title insurer. Many clients can't get that. They feel like, well, you'll never take my side of it because you're being paid by the title company. And then you may differ with the title company. These are very hard issues, but issues that are ethical issues that need to be examined, preferably on the front end. How many of you routinely circulate conflicts of interest in your firm? Yes? If you're not doing it, you need to do it. Put something in writing. You know, we're going to represent so-and-so as the owner or the plaintiff or the defendant, or in our case, often the buyer or the seller. So many disputes coming up that way. Has anybody in this firm ever represented them? That would keep you from being an advocate for whoever they've asked you to represent. This is really important. And let me say, looking at it from the disciplinary rules, I have not served as special master often in disciplinary, and I don't want to. I've done it twice. And the second time I did it, the accused lawyer was threatening suicide. And honestly, I don't think I did a good job with it because I kept trying to get him past the suicide before I could rule. I was terrified that if I ruled, he would just go out and kill himself. So eventually eventually I had to rule, and I did it. He didn't. But I'm just saying, these are very hard positions. Special masters in our disciplinary system are hard. And people say, oh, it takes so long. It takes a long time because the disciplinary rules committee of our bar are very committed to make sure that they're trying to do it right. So that's part of it. And
Carol,
yes,
were you suggesting like proactively doing it rather than a conflicts check? Or are
I
you
think you do
suggesting
a conflict check. You just ask everybody if there's been a conflict, and then you get a report. But not everybody remembers to do the conflict check. And that's what I'm saying. If you forgot the conflict check and now you're down the road and you figure out, you know, my partner here says this is our top client, you can't be suing him, and you've already taken on this client. So we want to identify conflicts of interest on the earliest possibility. And that's what part of being a zealous advocate. You can't be a zealous advocate if somebody is furnishing your bread and butter with somebody else in the firm. Right? That's an inherent conflict. As a negotiator, the lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealing with others. I just had a situation come up that I was discussing with a young lawyer that he's got a husband and wife, and the wife has said, don't tell my husband that I'm in this situation. How many of you think that's a conflict of interest? you're doing what the wife said, and the husband doesn't know it. I think it is. I think it's gotta tell that person to go back and stop that. Either get permission from the husband, from the wife or whoever it was who was saying, don't tell the other one, to tell or withdraw. You do not want to put yourself in that position, because in that case, you have not honest dealing with others. As an intermediary between clients, a lawyer seeks to reconcile their divergent interests as an advisor and, to a limited extent, as a spokesperson. A lawyer acts as an evaluator by examining the legal affairs and reporting. This is so important in what we do, and trying to communicate back and forth with our various clients in real estate matters. So I just wanted to ask yourselves, if you're doing a little self-test in your documents, would your client say that you took the time to give them a really informed understanding of their options and explain the practical implications? Especially if you're sitting at the closing table and there are 13 other closings waiting to close out in the hall. And you're trying to explain to these people who've never read the documents and want to read it word by word while you're politely smiling and waiting for them. You guys had that situation. Where does your obligation to explain this to the client? And of course, in the closings, who is your client? They're a lender. Is there who do you represent? That is definitely a source of a lot of complaints to the state bar. And so I would just ask you, think to yourself, what could you do to be a better communicator with your client? Well, I have an idea. How about returning the calls? You would be surprised how many bar complaints are because they didn't call me back. They left me stranded. They abandoned me. And not only that, people are so hair trigger tempers, it makes them mad. We had somebody call yesterday that said, I've been calling here every day to talk to a lawyer. And I'm like, no, ma'am, we have no record of this. Well, it turned out she was referring to her closing lawyer that she was trying to get in touch with, and she was trying to get us to help her get in touch with the closing lawyer. It wasn't clear, but oh my goodness, mad, very mad. And trying to explain all of that to her, I think she finally just hung up, which frankly, that was a blessing. Sometimes the better part of valor is to say, well, good luck with that. We wish you the best. And so would your colleagues say that you have dealt honestly with them? Now, like I said, there's a little bit of soul searching here, but if there's a colleague that you felt like you've not really been quite as transparent as you should be, fix it. Call them up and say, I'm just revisiting this, and I want to make sure we're moving forward with the knowledge that we need. Yeah, that's a different question than strategy. You're not obligated to share your strategy or how you plan to solve this, because you would not be zealously representing your clients. So you see this interplay between, I've got to zealously represent, I have honest dealings with my colleagues, but certainly telling your colleague what the strategy is and how you're going to solve the problem would certainly not be zealously representing your client. So I just ask you, for the last week, to your knowledge, have you returned all the calls you got this week so far? If you haven't, good news, tomorrow's Friday, you've got another day, and you can sort of do a checklist. Just communicating will help keep you also out of disciplinary problems. Have you any system for looking back on your files for the problems? Now, I'll tell you one thing, I think lawyers are so proficient in it. Does anybody know what it is? Starts with P. Procrastination. Don't you think we all want to get the new problem in and look good there, but the things that are kind of growing hair and mold over there in the file cabinet, oh, I still don't know what to do. I'll just deal with that too. Now, I don't know, like I said, y'all are a whole different generation than I came up with, but I read Gone with the Wind in the 6th grade. Nobody could believe my mother let me do it because of the word DAMN in there, but she did. And so Scarlett O'Hara, who is the heroine or the villain, depending on how you look at it, of Margaret Mitchell's book. And if you don't know, that is an Atlanta book. It was written by Margaret Mitchell. She's a very famous author. And it debuted here with Clark Gable and Vivian Leigh right down at the Lowe's Theater in Atlanta. So it was a worldwide premiere. Scarlett's thing, oh, la-di-da, I'll deal with it tomorrow. Tomorrow is another day. That was her famous thing. So tomorrow is another day could be the motto for many of us. Tomorrow is another day, Scarlett. Try not to let it tomorrow be the other day because you know tomorrow never comes. So tomorrow is today. So tomorrow never comes. So if you've got things that need to be done, I'm going to ask you just to take 1 minute and just write down 2 or 3 things that you know in your office that you need to do. Just take a second, write them down. They're not for me to share. They're not for you to share. I just want you to take a minute, write down 2 or 3 things that are on your list, your to-do list. And don't tell me you don't have any right now. Just 2 or 3 things, just 2 or 3 things. I'm not asking you to make, all 50 of them. Okay, so I'm going to ask you to consider getting those done tomorrow. Try to start on that list tomorrow. Because not only is it good for you and your reputation, but it also is in compliance with these professional rules that we're talking about, and it will keep you out of disciplinary trouble. Okay, now we're going to turn our attention from the rules that we've looked at so far to how some of these might apply to the title standards. And we're going to be talking about a couple of particular standards to start with. The first one is Title Standard 1.1 and 1.2. And I'm not going to ask you to quote those. I certainly couldn't have quoted them. But number 1.1, I thought was very interesting. And honestly, I don't know that I've ever read 1.1 before I started preparing this topic. But 1.1 talks about the title examiner. And 1.1 is the examining attorney's attitude. Did y'all know that? Did y'all know that was one of the title standards? Maybe some of you did. I did not. The purpose of the examination of title and objections, if any, shall be to secure for the examiner's client a title which is in fact marketable and which is shown by the record to be marketable and subject to no other encumbrances than those expressly provided by the client's contract. Isn't that what we call title exceptions? Isn't that why we have a list of all those items? Objections and requirements should be made only when the irregularities or defects reasonably can be expected to expose the purchaser or lender to the hazard of adverse claims or litigation. Well, now I have to say that is just a mouthful and seems somewhat contradictory. If you're going to make sure everything's done, but then you're not supposed to is it reasonably expected to expose the purchaser or lender? Hey, this is America. Anybody sues over anything. I mean, anybody could be exposed to something. So how do we draw that line? What is the title standards asking you as a practitioner to do? And if just as importantly, how are we going to communicate that? So the comment, I think, is instructive to some degree. It says title standards are primarily intended to eliminate technical objections. So I ask you all, what is the difference in a technical objection and an objection that would expose the purchaser or lender to the hazard of adverse claims or litigation? I see that as not black or white. It's kind of gray. And so the reason you're here today and the reason you're looking at title standards today is how do I navigate this very gray area? And is it gray? I mean, I've never seen a list that said, these are technical objections. Shut up. These could expose the purchaser because every situation is different. Titles, I did many years ago, I was a bit ridiculed, but I wrote an amicus brief for the National Mortgage Bankers of Georgia group, and it had to do with predatory lending and loans. And I said, loans are like snowflakes. There are not two that are exactly alike. You've got different situations that people are presenting. There are different needs they have, their families in different positions, and people just snickered. But it's really true. And in a situation, titles to some degree are like that. You rarely find the very same problem unless it's a subdivision line that's gotten off and everybody's got a clearer title. But rarely have I seen the exact precise issue come up again and again. There are variations of the thing, yes, So how are you gonna do that? What do you do then? Well, this is what the commentary says you're supposed to do. It says the examining attorney, a way of a test. Anybody ever thought about doing a test? May ask after examining the title, what defects and irregularities have been discovered, and as to each, who, if anyone, can take advantage of it against the purported owner. So that's our test. Is there somebody out there that could take advantage of it against the purported owner? If that's the test, that's everybody. I mean, I find this to be a very difficult test, but that's what they're saying the standard is. Commentary, look at the test. Is there someone who, if anyone, can take advantage of it against the purported owner, and if so, to what end? And then they give the example about the omission of the zip code as being not a material defect. Well, I think we all know that that's the case, and you probably have heard along the way, perhaps mine or others' presentations about the importance of having a good legal description and having a key, K-E-Y. Many years ago, I did game show a number of times for our section called Key or No Key, and I used the music from Deal or No Deal, and we had the time clock, and you had to say, is this legal description a key or not a key? And could it lead inexorably to the legal description in the recorded title? And we had people stand up and say it could, and we voted, we phoned a friend, we did all of those fun things. But the bottom line was, if there is not a good key, it's not an enforceable deed, it's not an enforceable contract, because you don't have good legal description. So this is not talking about a key, it's saying, is there the omission of something that is not a material defect for which you should raise an objection. And this is what they seem to be complaining about here. Listen to this. To enter an objection of such nature is considered to be fly-specking or to be over meticulous in the examination of the title. Okay, all you title underwriters, I suspect you hope people will be over meticulous and looking very carefully at what's been done. What's the difference in fly-specking and being over meticulous versus our standard up here when it could be reasonably expected to expose the purchaser or lender to hazard of adverse claims or litigation? I see a big hole. We could drive the truck right through there, but what does that mean? How do we use that as a practical matter? Well, that's what we're saying. We're normative ethics. How do you see that normally done? So most of the time, I think the way the title insurers, and those of you who are underwriters here, feel free to speak up and say you like this or you don't. I think if there's something that's come up, you would like to be called, would you not? And say, what do you think about this? What do you think about that? Am I right? Any comments?
I find problematic that we don't follow those standards anymore when it comes to deeds anyway.
Yeah.
So when I was trained, and I've been doing this for 31 years, not quite as long as you have, but there were documents that were supposed to be executed a certain way. LLCs executed in a certain way, corporations executed a certain way. And since 2008, that's gone out the window. So we can't even uphold our standards anymore for the most part, which is frustrating for somebody who's been doing it.
Back at these overall professional standards, what we're doing for the quality of justice, what are we doing to improve the profession? What can your group do? What can you do to do better training? What is the training? How should you teach this? What should you notify? And if you don't know, at least teach to call somebody, phone a friend, call the title insurer, call somebody to see what they think. God forbid that we're fly-specking or over meticulous, but what if you miss something and then all of a sudden it's costing your client, not to mention any of the other insurers, money? There's a dichotomy there. So I'm bringing that to your attention. Honestly, I'd never read that before. So before I started studying for this, that was intriguing to me. Then the next thing that we're looking at is at least if you're in that position, at least ask a colleague in your own firm. Ask somebody who has either more gray hair than you, or call somebody who might have run into this before and at least get another opinion and ask them, am I fly specking or am I over meticulous? God forbid either. The next title standard we're looking at is 1.2 called prior examination. And I think this ties into what we were just talking about our duties to each other and how we behave. It says, when an attorney discovers a situation which the attorney believes renders a title defective. Now, remember, we're overlaying this with everything we talked about above. And he or she has noticed that the same title has been examined by another attorney who has passed the defect. It is recommended that the attorney communicate with the previous examiner, explain the matter objected to, and I like this, afford an opportunity for discussion, explanation, and correction. The attorney contacted should cooperate fully and promptly in investigating his or her records and taking whatever steps are necessary to explain or correct the title defect of. Now, I don't know about you, but most everybody I know who has had any kind of experience in our lovely industry has had that dreaded call. Got the call, we've got a problem. Certainly in litigation, that's a call that we have to make because that's why we've been hired, fix this problem. So I want to ask you, somebody raise your hand and tell me, if you're the person being called, and this is, I'm sure not speaking from your personal experience, this is all hypothetical, theoretical. If you're the person being called, how do you want to be approached with that call? Somebody raise your hand. Tell me.
I mean, just approach it as, I found this in the back chain of title. We have a question about its execution.
Question about it.
And I'm just asking a question. Just want to know, did you get a copy of an OTP, previous OTP to cover the matter? How did you address it?
So the
And
answer
be
was,
very just,
you want it presented as a question, you've got a question about it.
and just be courteous. I mean, that's,
How about you?
Yeah, same. I normally just say, hey, we saw this, curious how you handled and did you issue a
Sure.
policy that I can rely on?
I have a question, I'm curious, we've hit this problem. But you do call them, right? Lachey, what do you think?
Or send an email, and when the email is sent, please love it when they provide what the issue is, instead of just asking for the OTP.
If you didn't hear Lachey, she says she likes it when you get an email and it's not just a call, but it says this is the issue. And I assume it would be like, we have an issue with the deed, we have an issue with a whatever it is, an encumbrance security deed located at such and such. I mean,
Give me as much information as you have available, especially if I have a file number on my deed, so that I can look it up. Because a lot of times I'm going to have that information if I can just figure out what file you're talking
and
about.
if you didn't hear me in the back, because the air conditioner is on, she's saying, give me all the information you can. Tell me my file number if you know it. Tell me anything that will help me go back to my file to find it. Information is power. Knowledge is power, right? So, go ahead.
so back in the day, we would have to go to a storage facility to find the file, to find out what was going on with the file. And you would sweat bullets, hoping you didn't miss a lien or you didn't miss a deed. Now, fortunately, we have the ability to answer very quickly, presumably online. And so it's a great facilitator of being able to answer those questions in the back chain if you need to. But back in the old days, I mean, it might be 3 or 4 days and you'd be sweating bullets all the time.
Well, first
wondering.
of all, you had to get in a car and drive to the storage facility, which was, several miles away because it was cheaper there than it
Yeah.
was there. And then you had to open the storage door and try to get some help getting all the boxes down. So this is how it was. But all of you are saying that now, really, there's no excuse for not finding the material if you have any kind of good reference. And the reference could be an address, preferably your file number. All the surveyors on their certificates have their certificate number on there. So at least if it's involving an encroachment or a title description dispute, you can at least go back to the surveyor because they're required to have it as part of their certification. So how long do you think is a reasonable time to respond to somebody? How long?
1 day.
24 hours.
Anybody else?
I think it depends on how old it was, how old the file is, because if it's
Depends on the length of time that you've got to dig back through things and whether it was scanned or not scanned from it.
right, a previous system, exactly.
I was looking for a deed this morning in North Carolina And I'm not sure if I'm gonna be able to find them without sending somebody to the dusty old archives up there, but in this particular area, the deed restrictions, they had some horrible deed restrictions, but this one said there could be no alcohol on the property. And that has come up with somebody who wants to open a restaurant and have a license. And like, we need to get this deed restriction out of this property before we can sign the lease. But finding that deed, it's gonna take a minute. So that may be different than what we're looking at now from something that was scanned. But going back to our prior point about not procrastinating, I don't know how you do yours. I don't know whether you keep a list of running lists of things that you need to check off, or whether you keep it on your computer, or whether you put it on the calendar and need to follow up on such a, but you need a follow-up system of some kind that works for you, so that you can get back to the person who's calling you. Because the worst thing is if it's holding up the closing, somebody may come back to you if there were an error and say, well, we're gonna look to you to make these damages right, interest is accruing, or we can't pay it off, or, some litigator's gonna make some ugly noises about it, right? So in looking at that issue, then we talk about the notice. We've afforded the discussion and cooperated. Now, what does that comment say? That comment says, and this is the word they've used, that's why it's in this topic, it is ethically incumbent upon the attorney raising the objection prior to discussing the objection with a client to locate the prior attorney, to discuss same with that attorney in order to afford that attorney an opportunity to explain what steps, if any, had been taken to clear the objection, and to offer the prior attorney the opportunity to clear the objection. Okay, I have a problem with that. Now, you're doing the title. Who's paying you? Your client's paying you to do this title. According to this, you're going to call the other attorney before you even notify your client. I don't think that's ethical. I think that may be in conflict with the earlier thing about being honest dealings with your client. So I guess I'm questioning that. To me, it seems like you would say, listen, we've hit a small snag. We're going to check with the attorney and let them know what's going on. Does anybody think that you should not tell your client first and call the other attorney first before you tell your client? I mean, you may. What do you think?
Well, I've had lots of situations where they find something that they missed and that was actually there. So it gives us the opportunity to check our title, see what was done, what was in our title, and I think it's pretty common that they've simply missed something.
Yeah, they could have
That
missed
is
something,
there.
but the question is, do you call the other attorney first before you tell your client? Or do you tell your client, I'm going to be calling the other attorney because we're checking on something in your title? What do you do, Peter?
I think it's courteous to give us the opportunity to see what's in our file, because then you're gonna upset that client.
So I'm just curious if you
Yeah,
agree.
we typically do that.
Shay?
I typically will call the other attorney's office first, because in order for me to give an update to my client, I need to know what timeline we're talking about as well. And I'm gonna find that
You may
out.
not even have a problem if they've already cleared it.
Correct. And so that's why I'm in the process of clearing title and my client knows that. So let me contact the other firm first and find out, okay, is this an issue or was it already cleared? If it's already cleared, then we're good. And if not, okay, how long do you think this will take so we can get a better idea?
No harm, no foul. No problem. You agree with that?
Yeah, I think it depends on the time frame. If I need to have title cleared by tomorrow, and that's the 1 day wait period that we're talking about, I'm probably going to let my client know that we may have a snag. I'm looking into it, and I will get back to you as soon as I have an
Way to
answer.
approach it. Did you hear hers? To let the client know that you're looking into it, you'll get back with. Well, continuing this comment, it says, in discussing the objection with a prior attorney, the current policy has been issued ensuring against any loss by reason of any such defect. If the title company will insure the purchaser against any loss by reason of this defect, should the transaction involve a purchase, or if the title company will insure the lender against any loss by reason of the defect, should the transaction involve only a loan, the attorney might consider recommending the purchase of title insurance as a solution to the title objection. Duh. I think we can all agree that would be certainly a smart thing to do. However, the attorney should counsel his or her client as to the distinctions between marketable title and insurable title and the possible consequences of failing to obtain a marketable title, as in maybe in the future you might have a problem selling. So then another issue that we come up with in connection with the title standards is looking at the next one, which is 24.4. Now, whenever y'all get ready to redo your title standards and look at them again, I made a note because I was an English major. There are two 24.4 sections. So I believe we need to add 24.5. So I'm just saying. Mistakes of court record clerks. Note the title opinion or certificate should accept to errors and omissions of court clerks and court employees as to matters incorrectly indexed or incorrectly recorded. And then 24.4 again is the title opinion which rejects the title or turns one down as unmarketable or uninsurable should be backed up with citations from OCGA or case law that pertain to marketability or insurability. This is essential for the attorney's own protection. Statements that the title is unmarketable without legal support would be unprofessional. So this is just a reminder, I suspect all of you do that, but this is saying, give me the site, give me the OCGA site, give me the case, tell me exactly why it is unmarketable so that you'll have a record of it. So this still dovetails with the professional rules of conduct as well as the lawyer's creed. Both the professional rules of conduct and the lawyer's creed really stress good communication. And how you make that communication, how you make that call courteously, professionally is really important, and or by email. So after you have been notified of a problem, what do? You try to not procrastinate and get it cleared up as quickly as you can. How you respond, the devil's in the detail. If you bow up, that's not going to help you. Everybody is going to make mistakes. Everybody is going to make more mistakes. We used to have a professor at the University of Georgia named Professor Ball who taught evidence, and he taught like he had Malcolm or Marble. And he always said, keep your errors to a minimum. We always laugh and say, that's crazy. Yeah, but that was good advice. You're going to make errors. Try to keep them to a minimum. And so the person who's going to ask for cooperation needs to respond. If that's you, need to respond. And my favorite saying for procrastination, and it applies to me procrastinating as well, we all do it, is like, it's like a kettle of fish. It will not smell any better next week. So we need to get on it. Back to the rules of professional conduct, lawyers should seek improvement of the law. And all of you, by participating in a seminar and being active in the real property section, are doing that, working on Todd and all these other great things that you're doing. If you're not actively involved in the real property law section, please get involved. It's a great group of people. It's the largest section, and you have a lot more clout for the bar than you probably have any idea that you do. And also consider, is there a way that you could either teach some seminars or be a little more available to people who need legal services? I find that the first-time homeowner is probably the most vulnerable person in our community of any homeowners, because they don't know what they're doing and they don't know enough to ask, and they're assuming that either the closing lawyer or the agent is their person and taking care of them, and they don't even understand that the GAR contract says even if the agent says something that's not true, you can't rely on it. You cannot rely on anything the agent tells you. And when you read that, you're thinking, well, why am I giving this commission? It's an issue. I think that when we look at the conflicting situations that the rules require with our colleagues, several years ago, we had a really important suicide prevention going on, and the state bar is still doing that. It's not quite as much of the headlines, but I want to urge you, as an ethical matter and as a matter of professional rules, if you sense that someone in your ambit is experiencing some mental distress. Now, every lawyer experiences mental distress, don't get me wrong. It's a stressful profession. But if you think someone is experiencing some mental health issues, please don't just assume that somebody else will talk to them. Take them to lunch, go and close your door, have a cup of coffee, and just say, you know, you seem to be under a lot of stress. What can I do? And even if it's nothing more than referring, don't wait. One of my favorite people in the world from college, and then went on to be a great lawyer and ended up as president of the state bar, Rob Reinhardt. Rob Reinhardt from Tifton, Georgia, nicest guy in the world. Unbeknownst to anybody, was having some issues and went out at lunch one day and went to his grandmother's house that he had grown up in, ended it. I mean, anybody who knew him would have given him anything to help him, but it's hard to ask for help. Lawyers are the worst about asking for help. So try to raise your consciousness enough just to be aware of that. The relationship to the legal system, I started out talking about how we all took an oath to the Constitution to uphold the rule of law and to try to withstand the temptation to pick a color of party to say, well, they're right, without evaluating whether the rule of law is being followed. We all need to be critical for ourselves of how the rule of law is being applied. I want to just remind you as a final point of the Lawyer's Creed. It's a really wonderful creed. It's in your paperwork, and also the aspirational statement, more on professionalism. But to our clients, I offer faithfulness, competence, diligence, and good judgment. I will strive to represent you as I would want to be represented. Sound familiar? And to be worthy of your trust. To the opposing parties and their counsel, I offer fairness, integrity, ability. I will seek reconciliation, and if we fail, I will strive to make our dispute a dignified one. To the courts and other tribunals, and to those who assist them, I offer respect, candor, and courtesy. I will strive to do honor to the search for justice. To my colleagues in the practice of law, all of us, I offer concern for your welfare. That's what we were just talking about. I will strive to make our association a professional friendship. To the profession, I offer assistance. I will strive to keep our business a profession and our profession a calling in the spirit of public service. To the public and our systems of justice, I offer service. I will strive to improve the law and our legal system, to make the law and our legal system available to all, and to seek the common good through the representation of my clients. I think that is the most wonderful aspirational creed. And if we could just each do a little bit towards that, it would improve not only our standing in public, but also our ethical responsibilities. Thank you very much for having me
All right,
today.
everyone,
And
that concludes today's seminar.